Well, welcome everybody. It's fantastic to have so many members and non-members online for this, the second in our online built environment event series. Today it's the legal event. We had a very successful event with our Scottish region in February. And so this is the second of four events. The next event is the Built Environment Fire Safety online conference on the 9th of July, and that's followed by a Health and Safety half-day online conference on the 17th of September. So if you haven't booked onto those, please do so. I just also wanted to highlight the face-to-face events that we're running. We had a very successful Building Control Conference in Hatfield in March, and we'll be repeating that conference every year. Around about the same time. Next year, we're looking for a larger venue, but keep your eyes out for that. We have two further face-to-face events this year. Our Built Environment Wales Conference on the 24th of June at Cardiff Metropolitan University, and our Built Environment Ireland Conference at the Clayton Hotel Dublin on the 22nd of October. So if you are in Ireland or Wales, please do think about coming on to those events. Onto today's event, we have a fantastic group of speakers covering a highly relevant and diverse range of topics. Please do contribute by asking questions in the chat. We do want this to be interactive. We had a fantastic level of engagement at the Scotland event where members weren't asking questions, they were also answering them for each other as well. So do treat this as a community and as a discussion as much as is possible online. But without further ado, I'm going to move on to our first speaker. So let's get started. Our first session is looking at case law and legal updates, and I'm delighted to welcome Paul Scott, who's a partner in construction disputes at Trowers and Hamlins LLP, and also Dr. Rebecca Rees, who is a partner at Trowers and Hamlins, but also a CABE Honorary Fellow, I'm delighted to say, and very much a friend of the association. So let's get going, and I'm going to hand over to Paul to start today's session.
Thanks very much, Richard. Can I have the next slide, please? There we are. So good morning, everyone. Welcome and thank you very much for joining. As Richard mentioned, the first part of the session this morning is a two-parter. Paul Scott, construction disputes lawyer, as Richard mentioned, and I think between Rebecca and I, we've got 45 minutes this morning, and I'm going to start and give you the first half of that on building safety related matters. And there's a lot to cover, so to avoid eating into Rebecca's valuable time, I'll just launch forward if that's okay. Can I have the next slide, please? So there we are, that's the two-part agenda, Rebecca and I. Next slide, please. Okay, so in terms of what I'm going to cover in the sort of first part of that session, it's matters relating to building safety law. And as a construction disputes lawyer, in common with, I suppose, every other construction disputes lawyer in the country, I've spent a good proportion of my time over the past sort of decade since the awful tragic events at Grenfell Tower, dealing with matters and claims and litigation linked to building safety related issues. The Building Safety Act was introduced a number of years ago as a reaction to that, and that's fundamentally altered the claims landscape. So I want to talk about that a little bit. Then I thought I'd very quickly recap some key Building Safety Act related case law. I'll do that quite quickly and canter through a handful of the sort of key cases. And I'll end up at the case of Crest Nicholson and Ardmore Construction, which those of you sort of keenly follow these things will have seen was a judgment that was handed down relatively recently, a couple of weeks ago, which is a further key and important case relating to Building Safety Act. And I'll try and draw together some key themes from all of the cases that I'm going to speak about, and I suppose give a bit of a suggestion about what I think that tells us about the direction of travel in reality and what the new landscape looks like and what principles we can draw from that so that we can look forward and maybe understand how things might unfold in the future on the back of all of that. And the last thing that I want to talk about, having sort of drawn the threads of the case law together, is the Construction Products Reform White Paper. I think all of the focus, or a significant part of the focus, certainly from a claims point of view, in the past 10 years has been in the sort of the contractor, developer, professional team sort of relationship environment. How have buildings physically come out of the ground and being constructed, and who's responsible for what? Although construction products and matters relating to construction products have been addressed and touched upon in a lot of the government-based reviews and the Hackett review and all of those sorts of things that have happened. From a claims point of view, focus hasn't really been on construction products at all in reality, or only to a very minor extent in comparison to the other things that I'm going to be speaking about at the start. There's a white paper, the consultation of which is closing tomorrow. And as we move forward from that, depending on what the outcome of that is and what the government legislates for on the back of all of that, that sort of focus might begin to shift, and in construction products and liability issues and all of those sorts of things might become more relevant and more important and more talked about going forward. So I'm going to talk about the construction products white paper at the back end of this session before I hand you over to Rebecca. Can I have the next slide, please? Okay, so I mentioned the Building Safety Act. Just got a little chart here which sort of shows, I suppose, potential routes to recovery. And those that are shaded up in blue show the sort of traditional routes that one might bring a claim or might create a sort of a network of claims and liabilities and obligations in connection with building safety matters, the sort of breach of contract, negligence claims, contribution claims, new home warranty type claims. The blue ones are sort of the traditional landscape, I suppose. We've then got in a kind of a purple colour the Defective Premises Act. And the reason that's in a sort of a purple colour as opposed to the blue and the pink, which I'll come on to, is it's, I suppose, a kind of a midpoint between the traditional routes to recovery and the new routes to recovery. The reason for that is that the Defective Premises Act has been on the statute book since the 70s, as you can see, DPA 1972. But prior to the advent of the Building Safety Act, it wasn't a particularly dare I say, important piece of legislation, important statute, certainly in piece of litigation that I was involved with prior to the advent of the Building Safety Act. The Defective Premises Act didn't loom large in reality. The Defective Premises Act is now far more important, and the Building Safety Act has changed that, because the Building Safety Act has fundamentally changed areas of the Defective Premises Act to make it more important. Principally, what it has done, the Building Safety Act has extended limitation periods for claims to be brought under the Defective Premises Act. And that means that claims for buildings brought forward prior to 2022 now have a 30-year limitation period. So buildings brought forward all the way back into the early 90s that can now be claims in connection with those buildings, as opposed to sort of 6 and 12-year limitation periods. So very, very historic buildings can now be the subject of viable claims. And moving forward, from 2022 in the Building Safety Act onwards, limitation periods for DPA claims are now 15 years. So again, extending the limitation period for those claims. So limitation periods alone, the Defective Premises Act has been very important, and a multitude of other reasons, which I won't necessarily go into in detail this morning, given that I want to sort of get through some of this and move on to construction products. That's the Defective Premises Act, sort of shaded in purple, and then in the sort of pinkish colour, there's a series of sort of new routes to recovery introduced by the Building Safety Act, which I'm going to talk about in the context of some of these cases. So remediation contribution orders, building liability orders, and then latterly that claims against product manufacturers, which is where we're going to end up when I talk about the white paper. Can I have the next slide, please? Okay, so some information on this slide. I think these materials will be available to everyone after the session, hopefully. But that sort of summarizes in a way some of the things that I've spoken about when I was showing you the last chart. So, some information in there which hopefully clarifies what I've just said. But if we can move to the next slide, I'm going to start to get into some of the cases. Thank you. Okay, so the first case I'm going to talk about is BDW and URS. I think before I kind of get into the specifics of all of that, I mentioned at the start that what I want to talk about is sort of key themes that we can derive from all of the cases I'm going to speak about. And I think probably just to set the scene before we do, the key theme that develops and that'll come out when I sort of talk through a little bit in the BDW and URS cases, the sort of the weight of momentum that appears to exist behind giving teeth to the Building Safety Act, the sort of the judicial support in the way that judgments are written and what is said in the judgments, the judicial support for what it appears the government has legislated for and what the government's trying to achieve by bringing forward the Building Safety Act. That sort of combined judicial and political pressure seems to be giving us a landscape in which liabilities are being spread far and wide, in effect. And things like SPV structures within developers, within contractors, are now less important as a result of building liability orders that I'll come on to. Limitation periods are being massively extended. Any areas of the Building Safety Act that require judicial consideration as to what might be fair and reasonable, the courts seem to be interpreting that quite widely, so that there's a kind of a real weight of momentum behind it. Will typically very often be considered to be fair and reasonable for liabilities that the Building Safety Act creates to fall as far and wide as possible in reality. So we've got a far wider sort of network and ability to make recoveries from all areas of the construction supply chain as a result of the things I'm going to talk about. And I think it's quite difficult to overstate how important and how fundamental the shift has been that the Building Safety Act has introduced. And obviously, in the context of the construction industry and what that means for developments that are being brought forward and what that means for claims in the context of historic developments. But I think actually, in reality, it's probably one of the most fundamental shifts of English law that there has ever been. And I know that sounds a sort of slightly dramatic thing to say, but the reason I say that is because it retrospectively rewrites some very, very fundamental principles of English law in the context of building safety claims. It rewrites retrospectively limitation periods, which is unheard of, I think, probably. And it rewrites this sort of ability to bring claims across individual SPVs and group structures. So, developers, contractors, parties that organise their affairs historically via SPV structures and group companies and groups of company type structures. At a stroke, I suppose the Building Safety Act has kind of rejigged all of that and fundamentally changed things retrospectively. So in the context of those two things, that kind of SPV structure and the ability to what the lawyers will call sort of pierce the corporate veil, and in what's happened in terms of limitation periods, the fundamental change that the Building Safety Act has introduced is absolutely fundamental, absolutely fundamental. So I'll talk quickly about BDW and URS. So it's a Supreme Court judgment, which is obviously interesting in itself because you don't get many of those in the Supreme Court. The history of this matter is that BDW brought forward a number of developments where URS were its appointed engineer. BDW disposed of its interest in a number of those developments, and all of this happened prior to the introduction of the Building Safety Act. It became apparent to BDW, having sold interest in some of these buildings, that there were design issues with those buildings. But crucially at this point, those design issues hadn't manifested themselves into defects in these buildings. So there's no physical damage, I suppose, at this point. And again, this is prior to the Building Safety Act. And BDW, having sold these buildings, brought a claim against URS in any event. And because we were in a pre-Building Safety Act time, the Defective Premises Act wasn't available to BDW because of limitation periods. And the issue that it faced, therefore, was that it had to bring a claim against URS in negligence. And from a legal point of view, that's not necessarily a straightforward thing to do. And in this particular case, the reason for that was that there's no physical damage to the building. So the category of loss that BDW would have been claiming here was categorized as pure economic loss, no physical damage. It's lost some money because of the state of the buildings, effectively. But also the added complication was it didn't own these buildings. So there's some issues that it faced here. The original court judgment, again, pre-BSA, decided that the loss and the damage that BDW were seeking to recover was recoverable in principle. It was recoverable per se because there was a proximity of relationship, and this type of loss and damage was foreseeable as between BDW and URS. The court also decided that the fact that BDW no longer owned these buildings wasn't a problem. So prior to the Building Safety Act, courts decided all of these things in BDW's favour in principle. Matters then move on, and the Building Safety Act is introduced. So the Defective Premises Act in its new guise is therefore available to BDW. And the matter then proceeds to the Supreme Court in the context of this now being a Building Safety Act, Defective Premises Act type matter, and BDW sought permission to amend and adjust its claim to reflect all of that. And the Supreme Court judgment decided that a number of things that are down there at the bottom of the slide. And all of those things, I suppose, that URS owed a duty to guard against pure economic loss, that there was no rule of law preventing recovery voluntarily across the DPA, that BDW was owed a duty under Section 1 of the DPA, though it was a developer, not a homeowner in itself. All of those things, I suppose, just support what I said when I first turned to this slide, which is the sort of the weight of judicial momentum that was sort of flowing in behind what was legislated for in the Building Safety Act, basically. So this case was sort of a ringing endorsement of the Building Safety Act and the Supreme Court very much giving teeth to what the government had legislated for. Can I have the next slide, please? Another case I want to talk to you about is Southwark Park Road. So this is a case where the first building liability order was made. So a building liability order is, in essence, an order whereby a group or a sister company of a company that has a relevant liability can be forced to make good upon that liability. So it's obviously relevant to the SPV structure point I was making earlier. And the sort of quite complex landscape around when it isn't possible to get a building liability order. But what was being sort of reviewed here was whether it was just and equitable to make that building liability order. And this was the first consideration of that, and the first building liability order was made. When something was just and equitable was considered in the context of the triathlon claim that I'm going to talk about later on a subsequent slide. That's triathlon's a case relating to remediation contribution orders, which we'll talk about later, which is a slightly different thing to a building liability order. But triathlon spoke about what was just and equitable in the context of remediation contribution orders, and sort of applying those principles of what's just and equitable in the context of building liability orders was what Southwark was all about. And in short, the building liability order was made, and in this circumstance, it was decided it was just and equitable. So I think again, this just shows the sort of the general sort of direction of travel, the way the wind is blowing is that giving teeth to the BSA effectively. Can I have the next slide, please? Right to adjudicate a DPA claim. So the next case I'm going to mention is BDW and Ardmore. In this case, BDW won an adjudication against Ardmore in the context of a building safety dispute. And for those of you involved in adjudication before, you'll know it's a short form alternative to resolve disputes in the construction industry as opposed to long-running expensive court proceedings or arbitration proceedings. Adjudication was introduced as a concept by the government in the late 90s with a view to giving a route to making quick recoveries and resolving construction disputes quickly. I suspect it is right to say that at the point where adjudication was introduced, probably the government didn't contemplate that adjudication would be used to resolve sort of complex, decades-old building safety type disputes. It was more intended to deal with sort of cash flow related matters. But the way that adjudication has grown and sort of developed, there's no reason why it can't be used to resolve any manner of construction disputes. And obviously, there's a lot of construction disputes around building safety at the moment. BDW brought this adjudication against Ardmore and they won. The adjudicator decided in BDW's favour. Now, Ardmore argued in front of the courts a number of things, but particularly important, I suppose, is point 2 on the slide at the fourth bullet point. Ardmore argued that the adjudicator had no jurisdiction to determine the Defective Premises Act claim, and the courts decided that wasn't right. The courts decided that an adjudicator could, in principle, decide the Defective Premises Act claim, and the adjudicator's decision was enforced. So what we have here is the courts arming parties with another route to prosecute building safety claims. So building safety claims can be decided by adjudication if that's what the parties choose to do. So again, it just sort of falls in behind this sort of which way the wind blowing theme that I'm developing here. Can I have the next slide, please? Triathlon is the next case I'll mention. I touched on it earlier in the context of building liability orders. Triathlon was actually a claim in the context of a remediation contribution order, an RCO. So an RCO is effectively an order made by typically the first tier tribunal where it decides if it is just and equitable to make an order against the party to make a contribution to the cost of remediating building safety disputes. So on the fourth bullet point there, the first tier tribunal has the power to make an RCO in relation to a relevant building if it considers just and equitable to do so. And in this circumstance, the interesting feature, I suppose, the Court of Appeal determined it was just and equitable for an RCO to be made against Stratford Village Development Partnership, which is the defendant in the case, and Get Living, its parent company, even though those companies were not involved in bringing forward the development at the time. They were just the current owners. So again, I'm like a dog with a bone out repeating these themes, but it just demonstrates the direction of travel of sort of spreading the network of liabilities far and wide. Can I have the next slide, please? just further information and interesting quotes from the judgment in triathlon. I think that the last bullet point or the last line there at the bottom is really interesting and important, though, that the court effectively decided that the Building Safety Fund, effectively the government-backed fund which provides funding in order to remediate certain categories of building, the Building Safety Fund should be considered a funder of last resort. So effectively, this is the court saying that there's a building safety fund there, which is government backed, but when there's an ability to make a recovery, however that might look, and from whichever sort of far corner of this kind of web and network of liabilities that I've been speaking about, wherever that liability may fall, that should be explored, and that the building safety fund should be considered a funder of last resort. And it's quite an interesting observation in the judgment there. Now, the next slide, please. Okay, that brings us to Crest Nicholson and Ardmore, which is a very recent case. I suspect that those of you who've dialed into these types of webinars and presentations previously will have heard a little bit about a lot of the other cases that I've been speaking about. You may have heard a little bit less about this case, although there's quite a lot of talk and publicity around it already. But you'll have heard a bit less because it's very recent, basically. It's a major recent Building Safety Act case. The facts of it are that Crest brought an adjudication against Ardmore connected to building safety issues in a development down on the south coast. It won that adjudication and it was awarded by the adjudicator around £15 million in damages. But the day before the adjudicator's decision was published, Ardmore went into administration. So Crest are sitting there with an adjudicator decision in their favour, but against the responding party, a defendant that had just gone into administration. Crest then brought this forward in order to seek building liability orders on the back of the adjudicator's decision. And there's a couple of things that are interesting from this, I suppose. It's the second case regarding the awarding of a BLO. So I spoke about the Southwark case earlier, but it's the first detailed judgment on what's just and equitable in the context of a building liability order. The first BLO case that I mentioned leaned heavily on what just and equitable meant in the context of RCOs and the triathlon case. So this is the first specific case relating to just and equitable in the context of BLOs. And I'd encourage all of you to read the judgment in detail, but broadly, what is just and equitable will be decided quite widely, I think, in common with the theme that I've been developing already this morning. There was actually two BLOs that were granted in Crest's favour here that have been referred to as the adjudication BLO, which is a BLO on the back of the adjudicator's decision. So the concept of get an adjudicator's award and ask the court to provide you a BLO in the context of that adjudicator's award has sort of been approved and rubber stamped in the right circumstance. And there's also an anticipatory BLO that was being issued. And the anticipatory BLO is given in the context where an adjudicator's decision, although sort of persuasive, and the strict legal status of it is that it's temporarily binding until the court decides these issues. So because the court hadn't yet decided the sort of the fundamental underlying issue of liability, it had only been decided by an adjudicator, it was necessary to seek an anticipatory BLO in anticipation of what court might decide in the future, were this matter to be relitigated by Ardmore through the courts. So the court looked at this and decided that there was enough behind all of this in order to grant an anticipatory BLO on the back of the adjudicator's award and an adjudication BLO in the same context, and that it was, as I mentioned at the start, just and equitable to do so in this case. So a really interesting case, Crest and Ardmore, with sort of potentially wide-ranging implications. It sort of sits into the context of the other cases I've been speaking about in terms of adjudications available to parties for these types of disputes and what just and equitable means. Can I have the next slide, please? Okay, I'm going to quickly talk now about construction products before I hand you over to Rebecca. I mentioned at the start the reform of the claims landscape post Grenfell Towers principally focused on developers and supply chain, and all those cases I've spoken about reflect all of that. Not many changes or substantial changes of law or really even focus on construction products, probably, although mentioned a lot, as I said, in the context of the Hackett review and all those types of things. The construction products reform white paper is the first step on the journey, probably to changing that. Can I have the next slide, please? So the problem that's faced is set out there on the slides. The safety framework is uncertain, I suppose, and that there's a huge number of products that are on the market and being utilised in buildings that exist outside of that framework. the system that sort of sits behind all of this has been critiqued heavily in the Hackett review and other things. And one of the things that came out of that review was the lack of sort of clear and adequate standards for testing and certifying and using construction materials. The consultation, all this closes tomorrow, as I mentioned. Can I have the next slide, please? So what it appears is going to sort of come out of all of this and this review following the closure of the consultation period is a far tighter regulatory framework that exists around the sale, the marketing and the use of construction products. A duty-driven framework, which will be a sort of a concept familiar to those of you who've been paying attention to what's happening in the context of sort of contractor-developer type relationships and those who own and bring forward buildings. That kind of duty-driven framework will be replicated, I think, in construction products. Accountability extended across the supply chain. I suppose that's probably my theme of the morning in reality, in terms of the cases that I've spoken about, sort of extending that accountability. Inability to rely on certifications alone is interesting. I think, certification of individual products will no longer be the sort of the be all and end all. It's how those products are being used and in what combination. That comes on to the next point around the golden thread. Again, a concept that everyone will be familiar with. But moving past simply listing products that have gone into a building and moving towards demonstrating compliance in the specific circumstances and combinations that products are being used. And manufacturers are going to be required to sort of actively assess safety and ensure that claims made are verifiable. Claims that are made around certain products is whether or not they're correct is something that's been sort of commented upon a lot in the past few years. And one of the other things that I suppose is sort of relevant is the specifying and using of products strictly within approved parameters. Products that are out there and being used in inappropriate combinations or inappropriate scenarios is going to be something that the framework is going to guard against going forward. And trackability of products and provenance, I can comment on this from a personal experience of litigating a lot of building safety matters over the past decade. Understanding specifically what products are in a building and where they've come from and what their particular performance criteria is very, very difficult at the moment. Record keeping isn't brilliant, going back to the golden thread, but knowing what something does, where it's come from, and how it might perform has been hugely problematic over the past decade. Can I have the next slide, please? So possible impact from all of this. Well, so when's all of this going to happen and when are all these things going to be introduced, if I'm right in what I suggest will be introduced? Commencement of all this is targeted for late 2027. Usual caveat these days around sort of what political landscapes might do to all of that. But I think there is a sort of weight of momentum behind construction products reform. So this is coming. Exactly when that will be is difficult to say, but late 2027 is sort of the suggested current implementation date. Very clearly there's going to be a sort of a serious impact on every participant in the supply chain. The verification and documentation and judgments that are going to be needed to built into every decision making is going to be key. It's going to change the way that things are done. There's going to be a new regulator that's going to be introduced. And I suppose that the likely implications for all of that and what we know from all of the different package of sort of initiatives that are being brought in by the Building Safety Act, that at least in the first instance, while people get used to the new environment in which they're operating, but very, very possibly going forward more generally, there's going to be a slowing of operations and an increasing of costs on site, potentially competition for resources in terms of things that products that have sort of been approved for use in certain circumstances, geopolitical matters and where products are coming from and availability of products is going to start to become very critical, I expect. So certainly in the first instance, the lessons that we can learn or the what we can draw from our previous experience in relation to the sort of developer, contractor, professional team landscape, if all of that is replicated as we start to look at construction products and how these things are moving forward, that kind of more restrictive regulatory landscape is going to have massive implications on site, certainly in the first instance, but probably for the medium and long term as well. Now, the next slide, please. And that is me, 10 o'clock on the dot. I hope I haven't eaten too much into your time, Rebecca.
Thanks, Paul. That was brilliant. Good morning, everybody. Thank you, Richard, for inviting me to talk to you very quickly about public procurement law. It is such a busy area of law at the moment that I've had to only take an overview and assume a slight working knowledge of the public procurement regime. If you can go to the next slide, please. That's what I'm going to concentrate on. I also just want to talk about procurement competency in the built environment and some of the work that's happened post Grenfell in relation to that. So, as you know, public procurement law applies when you are bidding to the public sector or you're acting on behalf of a public sector body when procuring construction projects. So you've probably, like us, been through the pain of bidding for appointments or indeed you're members of framework agreements. Brexit provided an opportunity for the politicians to seize back the strings of the public sector purse of UK PLC. And interestingly, public procurement law was the first thing that Boris Johnson and Dominic Cummings chose to send through what was then called the Number 10 Rules Reform Project. And indeed, even before we Brexited, a green paper called Transforming Public Procurement was published in December 2020. And that set out how UK politicians wanted to change the current or the previous procurement regime, which was derived from ultimately the EU treaty that came down into domestic law via EU procurement directives and into what was called the Public Contract Regulations 2015. It went through quite a bit of discussion, and I think the discussions were wide-ranging and didn't have to do with processes or evaluation or much to do with money. The range of conversations in the reform topics were immense and broad, so covered stuff like the treatment of the Uyghurs, the use of Chinese products in our national security supply chain, modern slavery, child trafficking. It went into very what we would call human rights law as well. So what do we take from that? Procurement is power, and who we choose to spend money with and how we choose to spend it is very determinative. And obviously, post-Brexit, we wanted to have more control over that. So the new spread of regulation that we have now is firmly anchored in the Procurement Act 2023, and that came into force in February last year. So we've had just over a year of new procurement rules. The procurement regulations, the statutory instrument 2024, also came into force on the same day and sets out a lot of details. And what I would do is signpost you to our website, www.trowers.com, and you will see on there there's an essential guide to the Procurement Act and the regulations. And please have a read of that at your leisure. Now, the interesting part is the transitional arrangements, which I'll come on to in a minute. But procurement is now what I call a political football. Each consecutive government will have an idea of what they want to achieve through spending decisions and procurement policy. We had a procurement policy that came in under the Johnson government, sponsored by Lord Agnew. That came in 2021. We were going to have a new procurement policy statement that came in with the Procurement Act in 2025. But you'll remember that the Conservative government was then replaced by the Labour government. And so that was quickly rewritten and was published on just before the new Act came into force on the 13th of February 2025. So the current National Procurement Policy Statement is a beast of the current Labour government. So is written in sort of mission-led language. And you will see, therefore, I think any national procurement policy statement will be updated when you get a new government in. And I would say that may be when you get a new leader of the same government coming in. So watch this space. It will be a dynamic area of procurement law. There's plenty of guidance on the Procurement Act written by the Cabinet Office and the Government Commercial Function, which I do commend to you. That said, some of it's wrong and some of it's unhelpful. So we do have to weave our way through it and not take it entirely on face value, but it's certainly useful at least to read, challenge it, yes, but it is the procurement rules written in plain English insofar as these things can do. Right, next slide, please. I just want to concentrate on the transitional arrangements. The main aim of the public procurement reforms was simplification. However, the transitional rules state that the old regime, as I said, the Public Contract Regulations 2015, will continue to apply to any procurement processes that commenced pre 24th of February and to any framework agreements and their call-offs where they were subject to a procurement process that commenced pre 24th of February as well. And of course, you've got very long-term contracts that existed pre 24th of February. All of those will still be subject to the public contract regulations. So at the moment, it is not a simplified landscape at all. We are still working with two sets of laws, and we have to apply them when it's appropriate to do so. You won't get a scenario where the Procurement Act and the Public Contract Regulations apply to the same thing. So that's the only blessing that I take out of that. Can I go on to the next slide, please? So I just wanted to talk about the reforms and how they might impact on CABE members. So as a tenderer, at the tender stage, you will start seeing differences in vocabulary, in what you're required to do, and what you're required to sign up to. You may have heard of the Central Digital Platform, which is an e-procurement tool. Now, as a tenderer, you have to sign up as a supplier, get your unique identifier, and place a whole load of information around your experience, your financial standing, etc., onto the digital platform before you are allowed to submit a tender to a public sector body. So please, I commend you to hunt that out if you haven't already done so. Where there is a contract that is let underneath the Procurement Act, there will be a requirement for contracting authorities, if that contract is valued above £5 million, to set 3 KPIs and measure performance against that. They also have to pay you within 30 days of an invoice, and they also have to report their payment performance against that 30-day period to the Central Digital Platform. I often find reminding them of that when there are outstanding invoices very effective in those outstanding invoice conversations. Do look at the new exclusion and debarment grounds, because if under a current or future contract you have remedies levied against you, or indeed the contract is terminated, that could affect your ability to bid for other public sector contracts, not just the ones that the client has enforced against you and going forward. So they have lowered the bar on what poor performance amounts to under current contracts. So again, commend you to go and look at those exclusion grounds to consider whether any of those icky contracts that we all have in our quiver will cause you problems, not just for that contract, but for future bidding performance as well. Confidentiality issues. I mentioned under the commercial life cycle that there are these 3 KPIs which need to be published and reported against. If a contract exceeds £5 million in value, at the point it is awarded, the client must publish what's called a contract details notice. Now, it may be that you're sitting there thinking, none of my contracts, or I'm never going to get paid £5 million for a contract that I'm performing. But if your IP and your designs or your specifications are being used to appoint a contractor or a developer or an infrastructure contractor, and that contract exceeds £5 million, then the client is obliged to publish that again on the central digital platform on its award. And you may therefore want to talk to the client about redacting any of your input into that large contract that contains commercially sensitive information or USPs or particular IP. So one to bear in mind. We're also seeing a lot of artificial intelligence limitations, but also benefits coming forward at the tender stage. Nothing to do with the procurement reforms, because bizarrely the Procurement Act 2023 doesn't mention AI at all. But do read the tendering rules, because we are seeing some clients absolutely forbid AI to be used in the preparation and presentation of tenders, or they ask you to confirm where you have used it and what for. So just some things to point out that we're seeing at the moment. If you're advising a public sector client for a project, again, remember that there are 2 sets of rules. So are you an existing contract and the public contract regulations might apply to any variation of that contract? Or are we in the realms of Procurement Act? Do you have to get involved in the monitoring and measurement of KPIs, payment performance, etc.? Do look at what you are required to do in terms of the Act and the regulations themselves. I've said that they're policy-led reforms. We are members of free trade agreements and the World Trade Organization's Agreement on Government Procurement. What the government was able to change was sort of made probably more significant by the fact that they chose to rewrite the procurement rules in British statutory language. The vocabulary's changed. There are significant changes where they were allowed to make them. So you need to be very alive to the detail on the Procurement Act, because the wording will have changed, and you need to understand whether that actually is just European into British statutory language, or whether the meat behind that change actually means you need to do something different. New documents and terminology are required. We are seeing a lot of rehashing of tender documents which don't quite work, or indeed give clients the flexibility that they've got now. And because the new procedures are so flexible, actually the detail in the tender documents is far more important now, and you need to understand what the client is asking bidders to do at what stage and what your involvement in that will be. Let's leave it there. Let's go on to the next slide, please. So what I would say is do have a look at Trowers' website, because there's loads of information on there. Other law firms are available and will have similar amounts of information. But I would say that we are still in a massive period of change. There's lots of questions about procurement law which have not been fully worked through at the moment, because Because of those transitionary provisions, we have had lots of procurements run under the old regs that are still just coming to fruition, even though they've taken over a year. And therefore, the full impact of the reforms will take years to come through. What I've talked about the changing of the National Procurement Policy Statement being used as a political football, but we also have, and it was introduced under Georgia Gould when she was Minister of State for the Cabinet Office, the consultation on jobs, opportunities, employment and skills. So this was the Labour government actually wanting to change the primary legislation, which is why I've called it Procurement Act 2.0, to bring in some of that mission-led policy into the face of primary legislation. It seems to have been kicked into the long grass at the moment, and the government response to consultation came out just before Easter, and it said that they would take forward the recommendations when parliamentary time allows. So it seems to have been kicked into the long grass at the moment, but just to say changes will be coming. As a lawyer, I love a good case. We've now got our first reported case under the Procurement Act, and that was about the lifting of an automatic suspension. If somebody challenges a procurement decision, they will need to go to the High Court, normally the Technology and Construction Court, and obtain a claim form. This issue and the service of that claim form automatically suspends the procurement decision or indeed the entire procurement process, meaning that the public sector client cannot proceed with the process or the award of the contract. Under the previous regulations, and indeed the judges that sort of filled the TCC in the Court of Appeal, a very client-friendly approach was adopted. It was very rare that those automatic suspensions were maintained. And therefore, as a bidder, there was a bit of a question mark as to why bother. We're not going to get an effective remedy because the automatic suspension is going to be lifted. And then the case law or the domestic case law under the public contract regulations were such that the likelihood of receiving damages for the loss of that contracting opportunity was very remote. This case, Parking Eye Limited, seems to be turning the tide on that. It's a very closely reasoned judgment, but it says, look, this is in the public interest to maintain the automatic suspension so we can go and find out what actually went wrong here. It's not about would damages be an adequate remedy anymore, as it was under the previous rules. We're going to go and have a proper look and maintain this automatic suspension. So, tide is changing. We're not standing still. Am I losing time now, Richard? The only couple of things that I just wanted to say before we get on to is just about procurement competency. Can we just go on to the next slide? I'm going to leave that. Just public procurement professionals in the built environment. Next slide, please. Have a lot of competency frameworks. And again, please. And again, please. There are a lot of competency frameworks to cover. And with all of the changing in legislation, it's important to understand for procurement professionals in the built environment that they have a lot of things going on. At the moment, the competence framework that SIPs have published concentrates on good procurement. And the only thing I would say off the back of this presentation today is to concentrate on what I call safety critical procurement. We can run a fantastically compliant procurement in accordance with the Procurement Act and in accordance with the SIPs guidance, and yet end up with poor quality and safety outcomes. And therefore, what I would commend you to do is look at the competency framework that has been published and pick out the safety critical actions that the procurement professional needs to hang on to in order to produce quality and safe outcomes. Right, I shall leave it there, Richard, because you've come onto screen and I think you probably want to ask some questions.
I think fantastic, and thanks very much, Rebecca. Thank you very much, Paul. A couple of questions. I mean, brilliant overviews and huge amounts in there to get it stuck into after the session today. But two quick questions. First, from Rob Gary for you, Paul. Is the natural progression from the changes to the Defective Premises Act to enact Section 38 civil liability of the Building Act 1984? And wasn't that supposed to be the case when the Building Safety Act came into force? Section 38 is quite a section, I think it's fair to say, in terms of its implications. But Paul.
Yeah, it probably is. Whether that will happen or not, I don't know. But obviously, when the Building Safety Act was introduced, one of the things that we all sort of, as lawyers, sat down and spoke about and thought about and looked at was Section 38 of that Act, because it sat there on the statute books for. I'm only slightly older than it, basically, let's put it that way. So it's sat there for sort of 40 years untouched and unused in effect. So that was one of the, as we did our sort of horizon scanning, which is a posh word for guessing what might happen. That was one of the things that we all spoke about, but in reality, it hasn't really impacted what we do as construction disputes lawyers at all. In reality, whether or not that will change materially as we move forward, it does feel like it was teed up by the Building Safety Act and is there and available. Yes, I suspect so, but I did think that a number of years ago, and it hasn't quite filtered through yet.
It has, yeah. I wonder whether there is a little bit of caution in waiting to see just how exposed the industry is before introducing that as well. And I think that's probably a fairly sensible move from government, given the implications of opening things up that way. So great. And Rebecca, I've just got a very quick question for you. So we've spoken for years now about the role of public procurement in determining outcomes from projects. Do the most recent reforms to government procurement do anything to make procurement outcomes safer? And if so, how?
Um, Absolutely not. So the the section where you um, uh, achieve safety critical outcomes will be through the bits that happen outside of the procurement process itself and outside the scope of the Procurement Act. So the specifying, the appointment of competent individuals, the selection of your contractor on quality and safety led criteria. All of those issues, and then the management of the contract, right? When it's on site, all of those, what I would call safety critical actions within a procurement process are not covered in the Procurement Act, and they have nothing to say to it. What my recommendation is, particularly when we look at the competence framework for procurement professionals, is that we have a requirement to lend enough time to all of our actions in that critical path of a building project to make it safe and quality led. Procurement is not immune to that. There needs to be a good amount of time and a good programme to allow all of those quality and safety critical items to be progressed and checked and rechecked. And that's really what the gateway process is designed to do. So the MHCLG Procurement Advisory Group issued guidance on collaborative procurement processes, and that knits into the gateway process those good procurement or the attributes of a good procurement decision-making process to those gateways. So I'd commend that to you as well.
Fantastic. Okay, well, look, time has moved on, but thank you both for a fantastic opening session. I'm sure that we will speak again soon, but we're going to move on to our second session now. But thank you again, and fantastic work.
Thanks,
So, second session this morning is on tax and employment. These are matters that we all need to understand better. I think if my experience is anything like that of others, we begin our careers as professionals dealing with technical or contractual issues, and then we become employers or managers, and these areas are not our natural areas of operation or expertise, but absolutely vital and fundamental to virtually every business and operation. So I'm delighted to have speaking with us today, Christy Willis, Associate Solicitor at Palmer's Law Limited, and Susan Bell, who's a council member, past president of the Chartered Institute of Taxation, and currently a business owner and working with Smiths Consulting. So without further ado, I'm going to hand over to Christy to start the session.
Thank you. So, hi all, I'm just going to be talking today about the Employment Rights Act 2025, which you may have seen about in the press over the past year or so. So it actually was very went through Parliament at the end of last year. It's going to be coming in over the next few years. There are a lot of changes that we need to be aware of here, so I'm just highlighting the main ones to draw to your attention, but there is a lot more just to give you a heads up. So if we can go to the next slide, please. I've just got a little introduction there in terms of who we are. I work for Palmer's Law. We are a regional law firm based in Essex. And if you can move on to the next slide, please. We're pretty much full service. We do a bit of everything. But I mean, in terms of the commercial side of the business, just a couple of things to highlight in terms of construction, commercial disputes, obviously employment and HR related services, commercial property, but you'll see that from the slide, there's quite a lot more than that. So if we can just move on to the next slide. Yeah, so that's just a list of the offices. And then onto the next slide, please. Okay, so in terms of the Employment Rights Act, there are some changes that have already come into force. So some of them came in quite quickly. As I said, I'm not going to highlight everything. There is a lot here. There is a lot that's coming in and a lot that has already come in. So I haven't focused particularly in terms of the trade union changes or anything like that, but tried to focus on the main issues that may cause you problems. So from April 2026, so this is already in force, unpaid parental leave and paternity leave become day one rights. So from your first day of employment, sexual harassment has also become a protected disclosure. Now, there's always been an argument that it would have been anyway, but essentially they wanted to make it clear. Employers may also want to consider whether they would prefer to investigate sexual harassment complaints within the scope of whistleblowing policies now rather than standard grievance procedures, for example. SSP, there's been the removal of the waiting period and lower earnings limit. So essentially it's payable from day one of absence now. In terms of the working time records, this was one that was brought in by surprise. So it was only announced about a week before it came into force that it was coming in, but there are certain required records that now must be retained for 6 years from the date on which they are made, and failure to do so will constitute an offence which is punishable by a fine. So you need to be on top of that one. And as I said, there was no real warning that that was coming in April, but that did come in, so be aware of it. And then if we can move to the next slide, please. So there are lots more changes that will come in over the next year to 2 years. So just some key dates here, and I'm going to talk about these in some more detail shortly. So from October 2026, there is a duty to prevent harassment changes. So there are changes to that duty, and I will talk about that more shortly. And at the moment, all we've been told is no earlier than October 2026, there is going to be an extension for the time limits to pursue employment tribunal claims. So at the moment, most employment tribunal claims, you get 3 months less 1 day to pursue the claim. That's going to increase to 6 months. So again, 6 months less 1 day. So it's going to extend the time frame for employers in terms of when they need to be watching out for a claim when they at that kind of uncertain period. And then from January 2027, there will be a reduction in the unfair dismissal qualifying period. So this has been quite a key point in respect of this. There's been quite a lot of information and it's been quite relevant in the press here. And then also changes to the fire and rehire provisions. So again, we'll go through that in a lot more detail soon. And then all we've got at the moment is sometime in 2027, so we don't know when yet. There are going to be changes to 0 and low hour contracts, quite significant changes, and changes to the provisions in respect of flexible working. Okay, so if we can move to the next slide, please. So harassment and sexual harassment we're going to talk about first. So next slide, please. As I said, sexual harassment is now a protected disclosure. That was been since April of this year. Employers are now going to be required to take all reasonable steps to prevent sexual harassment. And this is from October, essentially. So all reasonable steps to prevent sexual harassment. At the moment, we don't really know what all reasonable steps is going to be, but it's likely to be very wide. So there was a duty already that came in last year, no, the year before, in respect of changes that then you need to take reasonable steps to prevent sexual harassment. This is essentially extending that, so it's going to be much wider. The government can specify what will be regarded as the reasonable steps an employer should take or has failed to take to prevent sexual harassment. But bizarrely, it's not expected that these are going to come into force until 2027, 2028, because they are intended to consult on this. So unfortunately, employers are going to be left in this position where this kind of guidance hasn't been released, but they are still subject to the duty. So it's a bit of a strange one. Employers are also going to be under a duty to take all reasonable steps to prevent third-party harassment in relation to all relevant protected characteristics. So this is not only sexual harassment, it's everything. So age, disability, race, anything along those lines. A third party is someone other than the employer or one of its employees. So for example, if you're working on site, it could be an employee of a different contractor, or it could be a client. Anything like that, they would classify as a third party. There is not going to be any requirement for the employee to have been harassed by a third party on a specified number of occasions, or for the employer to have had knowledge of the harassment. So it's not going to be a case that you've had a warning and then if you don't take any steps to prevent it, then you're going to get caught out. It's going to be from the first incident. So, you really need to be thinking about these things in advance. You really need to be considering proactive risk assessments, training, clear escalation mechanisms to try and meet these requirements. But as I said, they are going to be really wide. So, you're really going to have to risk assess everything, make sure all employees have training, and they're told to report incidences that they see, for example, including other people. And all of those escalation mechanisms are very clear to employees, and they're clear that it's going to be taken seriously. So if we can move on to the next slide, please. So in respect of unfair dismissal, that's what we're going to be talking about next. So the government originally intended to make unfair dismissal a day one right, subject to some form of probationary period. And this was one of their headline measures. Essentially, it came under a lot of criticism in the House of Lords, and eventually it was decided that the current 2-year qualifying period would instead be reduced to 6 months. Okay, so people are going to have unfair dismissal rights much sooner moving forward, and they have also removed the power to vary the unfair dismissal qualifying period by regulations. Essentially, that's going to make it much more difficult for there to be any further changes to the qualifying period. So, for example, if a future government came in and decided, actually, we don't want 6 months anymore, we want to take it back to 2 years, it's going to be much more difficult for them to do that. It seems likely currently that the reduction will apply to cases where the effective date of dismissal is on or after the 1st of January 2027, although we're still awaiting confirmation of that. Employers need to be very careful on this because essentially, anyone you employ at the beginning, from the beginning of June onwards, is likely to have 6 months service on the 1st of January and would therefore be caught in respect of this. Employers are going to need to be much stricter with their probationary periods. So if we can go on to the next slide, please. So yeah, you need to be much stricter with probationary periods. Any issues need to be dealt with within the first few months, really. You don't want to be sitting at 6 months and then telling someone that they failed their probationary period, because ultimately you could end up with an unfair dismissal claim because obviously they will have reached 6 months service. A lot of employers are considering reducing their probationary periods now, just to highlight that these kind of things need to be dealt with earlier. And also managers should be trained to recognise and intervene early if performance issues arise, so that we're dealing with them much earlier. You're not going to get the opportunity now to see how things pan out. If there are issues, we need to be dealing with them much earlier so that they don't get to that 6 months service. Obviously, there's still going to be the unfair dismissal claims that are automatic. where there is no qualifying period, but most employees will fall under the ordinary unfair dismissal provisions and therefore will require 6 months. There's going to be the removal of the compensatory cap for unfair dismissal claims. So this is going to be particularly relevant in respect of high earners. You know, currently it may be the case that actually it's not really worth them pursuing an unfair dismissal claim because the cap, often they agree a settlement very quickly because they know that's the maximum they can achieve. But that's not going to be in place anymore. The thinking behind this was that the government felt they would probably reduce the amount of more complicated discrimination claims where people are trying to avoid the caps, but we'll have to wait and see if that plays out. The increase in tribunal time limits, as we've said, it's going to increase to 6 months, is definitely going to prolong uncertainty in respect of unfair dismissal claims as well. So it's kind of from all sides. If we can move on to the next slide, please. So just a brief point in respect to fire and rehire. You may have seen this, it's been quite a key point recently. So on to the next slide, please. So originally the pledge was to ban fire and rehire entirely. That hasn't been the case, but it is going to be possible only in very limited cases where the employer is in financial difficulties, and there's going to be quite a strict test in respect of this. Obviously, we haven't got time to go into it in depth now, but it's definitely something worth looking into or getting advice if you're in that situation. Dismissal, where the employer sought to vary the employee's contract, so obviously it's specific variations that will be covered here, will in many cases become automatically unfair. The financial difficulties exception to fire and rehire is narrow. It requires strong proof that changes are essential for business survival, and it is going to be very strict. The other thing to bear in mind is that it only means that the dismissal is not automatically unfair, but the tribunal will still have to assess whether the dismissal is ordinarily unfair, so unfair in the usual way. It's also going to apply to dismissals where the employee is replaced with an agency worker. So, for example, a few years ago, some of you may remember that there was a lot of press regarding the P&O Ferries case, where essentially they replaced lots of staff with cheaper agency workers. This is going to try and avoid that. So on to the next slide, please. So 0 hours and low hours contracts, essentially the government is trying to put people off from using these. They were initially talking about a ban, but again, they've just made it a lot more complicated. So on to the next slide, please. There are going to be new regulations which require employers to offer contracts with guaranteed hours based on the workers' regular patterns over a reference period. The government is under a statutory duty to consult on the length of that initial reference period and any subsequent reference period. So it's not going to be a one-off obligation. It's going to be every single time they meet that requirement. It's currently expected that the reference period is going to be 12 weeks because that's what the government have said their preference is. But they are coming under pressure in respect of that. So the British Retail Consortium has called for the reference period to be at least 26 weeks or ideally 1 year, bearing in mind seasonal working. And they essentially think that that would work better. And there are going to be anti-avoidance measures that are going to come into force at the same time. So, you know, it's not going to be easy to get around these. So on to the next slide, please. Employers are required to take reasonable steps to ensure that workers are given specified information in relation to their rights to guaranteed hours during an initial information period, and the detail of the information to be provided we're currently waiting for. It's going to be set out in regulations. And it's worth noting that that has to be available all the time. So that kind of information is a good idea to have on the intranet, staff handbook, where people can access it easily. Employees are going to have rights to reasonable notice of shifts and compensation for cancellations or changes impacting operational planning. So essentially, you're going to have to be a lot hotter in terms of planning. You can't make last minute changes. And if you do, you're probably going to be required to pay the employee at least part of what they would have earned anyway. When notice of a shift has been given and the worker has agreed to work the shift, the employer will have to give reasonable notice to cancel that shift or make any changes to the day or time of the shift or the number of hours to be worked during that shift because of a break, for example. It also includes a multi-worker request. So if, for example, you're sending out on a WhatsApp group and you're asking people to work and more than the number of people reply than you actually need, potentially, you could be in a position where you have to compensate them for not offering them the shift. Obviously not a great position to be in and something that you need to be really careful of. This is going to be automatic unfair dismissal. If there's any dismissals as a result of this, there is no qualifying period, and there is going to be provisions in respect of the right not to suffer a detriment as a result. So on to the next slide, please. Okay, so flexible working. On to the next one, please. So obviously flexible working has been in for quite a while now, but the Employment Rights Act introduces a new reasonableness requirement for employers when refusing flexible working requests. Currently, you can refuse a request on one or more of the prescribed statutory reasons, and the reasonableness requirement is likely to make it more difficult to refuse that request. The reasonableness test will be considered against the existing 8 business reasons for rejecting a flexible working request, and when refusing an application, the employer will need to state the ground or grounds for refusing the application and explain why it considers it's reasonable to refuse the application on that ground or grounds. There are other requirements as well, but they are key ones. So on to the next slide, please. So what should you be doing now? This is the last thing that I'm going to talk about before we pass over to Susan in respect of the tax position. So if we can move on to the next slide, please. So now you should be reviewing your harassment policies, risk assessments, reporting processes, make sure that everything is up to date, make sure that everyone's done their training and everyone is aware of the concerns and what steps need to be taken. So employees and managers need to be trained to recognise and report harassment and understand what steps should be being taken. As we said before, review probationary processes and management training to ensure that employees are monitored effectively during their probationary periods, so any issues are dealt with before they get to 6 months qualifying service. Definitely review your employment contracts urgently, so as soon as you can, make sure that you are happy with them, and flexible working policies. Again, in respect of 0 hours and low hours contracts, you're going to need to review how shifts are planned and allocated and ensure that you have systems in place to be able to meet the requirement to offer guaranteed hours contracts as required. And as I said, that's going to be an ongoing obligation. It's not going to be a one-off. It's going to be on repeat. So you need to make sure that you've got that admin in place, that you're set up for that. Okay, if we can hand over to Susan now. Yeah, she's going to talk to you about the tax part. Thank you all.
Thank you, Ruthie. As you can see, obviously status is employment in relation to employment law, because if you're an employee, then rights attached to it. But what we might see is that where this is going to fit in with the tax legislation and what particular aspects you have to look at when you're engaging people. So it's also where we see common mistakes made, and they can be increasingly costly. So let's start with the big picture. So if I can have the next slide. So what we might have is obviously direct employees. We might have workers under employment law, agency workers, self-employed subcontractors, or intermediaries such as personal service companies, or even umbrella companies. And different tax regimes apply potentially depending on what you actually have. So it's key really to look at what you're actually engaging and work out what they are. Obviously, first off, employees, and then you'll be able to deal with the employment law aspects as well as the tax aspects, and then work your way through. The risk, obviously, if you get it wrong, is that you could be liable in certain cases for tax and national insurance that hasn't been deducted, and that can be quite important. HMRC actually look at the reality over paperwork quite often, and just because somebody has a label saying they're self-employed or submits invoices doesn't necessarily mean for tax purposes that that's the case. So first of all, we're going to look at the foundation, which is employment tax, i.e. are you employee or are you self-employed? So that's the next slide, please. So when you're determining status, obviously it makes a massive difference, as I said, because if you have somebody who's employed, they'd be taxed under pay as you earn and have national insurance applied. But if they're self-employed, you may be able to pay them gross. Obviously, we'll come on to aspects of that as we work through this. HMRC kind of look at three key things: control, personal service / substitution, and mutuality of obligation. And I'm hoping that all of you know a lot about this. But I think what we can say is that recent case law has highlighted again how important this is. Most of the case law is actually related to off-payroll working IR35, but we do have other employment cases as well. But what it does reinforce is that some of the case law and the stage process we need to go through actually goes back to Ready Mixed Concrete case, which is actually from 68. So personal service, control, and actually looking at the whole relationship are quite important. As I said, one of the recent cases that you might have seen is actually on the football referees, the PGMOL case. And again, that reinforced that looking back and looking at the whole picture. So that's quite important. So there's no single factor that just decides it. But where does that leave us? Well, we're discussing that, and HMRC, obviously, whether they'll be updating their CEST tool, which you can use to check employment status for tax. HMRC still uses it, and there is some importance still to using that, because actually, if you are looked at by HMRC as to whether your process involves the right things for checking employment status, they will use that as an aspect of reasonable care. So if you use CEST, they will say reasonable care has been taken, obviously presuming, of course, that you correctly answer the questions. That doesn't mean to say that you have to use it, but just that you need to have a process in place which actually assesses how you determine status. What we have had over recent years is obviously that tribunals have repeatedly shown us that long-term site workers are often employees, even where you may have treated them as subcontractors. You know, so if somebody turns up every day, uses your equipment, follows your instructions, or somebody's instructions that you have also engaged, then that's a high risk. But we don't have, you know, a tick box exercise. It's a judgment, and it is complicated, unfortunately. So that's the sort of very basics, and hopefully you all know all that. But what else do we have to consider? We've got other rules on top of that. So if we can move on to the next slide. We'll briefly cover the IR35 off-payroll working rules. So these apply where individuals work through intermediaries such as a personal service company, but they can be other things like partnerships, for example. And the key question here is who decides whether there is tax to be deducted or not. And if you're a medium or large business and engaging off-payroll workers, then you will need to decide. If actually you're not, you're a small business, then you can actually pay gross, and it relies on the individual worker to sort out their tax under these particular rules. So have we had any changes around here? Because obviously these rules have been in for some time now. Well, yes, we have, because we've changed in relation to what is determined as a medium or large business. And if they meet 2 out of the 3 tests for 2 consecutive years, and the turnover test now is 15 million, the balance sheet is 7.5, and it's more than 50 employees. This changed in April 25. So we might have some cases now of people actually dropping out of having to operate the rules, but that's more likely to happen because of the 2-year rule, obviously, as we get to April 27. But it's worth just remembering that if that's applicable to you. So the key here is obviously that these rules use similar status tests, which are just applied to intermediaries. So you effectively presume that the intermediary is no longer there, and would you have had somebody who's an employee, or would they have been self-employed? So inside IR35 or outside of IR35 is what we often use as terminology. And you have to make those assessments first, because obviously then you have to decide whether you need to operate tax and national insurance as though they were an employee, deemed employee. Again, one of the things that's worth remembering is that obviously we've had the rules for some period of time, but in April 24, we had a situation where actually, if you make a mistake and you get it wrong and you don't actually deduct tax and national insurance when you should have, we now do have at least a provision for set-off. So we're not going to see some of the eye-watering liabilities we've seen perhaps previously in future years, because hopefully, obviously, tax and national insurance will have been paid by the individual, and this can be set off against any liability. So at least it reduces the engager's risk. But they're not the only rules we've got in place. Perhaps if we can move on, we need to look now at agency workers. So thank you. So this can get tricky quite quickly, and we've got some changes coming up, but I'm going to kind of cover it in 2 bits. So first of all, agency rules can override self-employment. That's because we have different tests and a narrower test under the agency rules. And the agency legislation applies if all of these conditions are met. The worker personally provides services to the client. There is a contract between the client and an agency, and the worker is under supervision, direction, and control, or the right of it. And the worker's pay is not already treated as employment income. So if any of these fail, then actually the agency rules don't apply. But we haven't really seen this tested greatly in the past, but we now have a case from 25. So it's Tyler Security Limited, where the tribunal confirmed that the agency rules applied due to supervision, direction and control. And in this particular case, the workers were subject to instructions, site rules, KPIs. There was training, supervision and monitoring existed, and the engager had disciplinary powers and task allocation responsibilities. So again, the tribunal looked at the actual working practices, not just the contracts. And in this particular case, because supervision, direction, control applied, pay as you earn applied. So the importance here is obviously understanding supervision, direction, control. It's very wide and factual, and it's easy for HMRC to prove. So where do you think you might have this problem? Well, if you're using an agency, obviously the key is for you to understand where potential liabilities might apply in relation to you and your risk. And obviously if they're operating tax under national insurance and pay as you earn a national insurance or not. You also need to be very careful that agencies will ask you questions potentially around supervision, direction, control, and that you answer them correctly. Because if they rely on an answer that you've given and it turns out to be incorrect, then the liability can shift to the engager. But it is only in specific circumstances. But obviously agencies do quite often ask engagers about those particular criteria, because obviously they're not going to necessarily know in enough detail to make an assessment as to whether they should be operating pay-as-you-earn national insurance or not. So the emphasis is you can't really assume that the agency is dealing with it, and you need to be clear and you need to ask certain questions, and you need to also document if you have given any information about supervision, direction and control, what it is you've given, and equally, I guess, also if it changes over a period of time. So that's just the agency rules. Now let's come on and talk about CIS. So perhaps the next slide, please. So where does the CIS, the Construction Industry Scheme, fit into all this? Well, first of all, we should be reminded that it's not an employment status test on its own. It doesn't mean just because you operate tax deductions under this or somebody has gross payment status that they are genuinely self-employed. You need to make that assessment yourself. It is just a deduction mechanism, so it's effectively tax paid on account. So obviously, if you're a contractor, you need to assess the status if somebody's self-employed or not. If they're engaged by you directly, you need to do verification, you need to make deductions potentially depending on their status, and you need to make returns to the revenue. But CIS can also apply to payments to intermediaries, as we've seen, and as you all know. And we've had a case on which was quite complicated in relation to Harbonk Recruit in 2025, where workers were treated as employees for pay-as-you-earn under the agency rules due to supervision, direction and control, but there were also obligations under CIS. So I think without going into it in too much detail because of the time, what you really need to bear in mind is that you need to understand in each link of your labour supply chain and understand where pay-as-you-earn and national insurance might apply and where the CIS legislation might apply. As again, there are situations where you could hold the risk for those liabilities. And the risks particularly increase now under current legislation where you perhaps using umbrellas. So we come on to the next slide. So under umbrella companies, we've had legislation, we've had changes where we might shift liabilities. And these apply from April 26. So you might have joint and several liability now, and the liability effectively moves up the chain. So what we're talking about here again is a labour supply chain where potentially we've got other parties to it, and we need to work out who is responsible for tax and national insurance and whether we might, in certain circumstances, have any liability if there's a failure in that supply chain. So I think that's the key bit. Is quite often you have an agency situation, and an agency might subcontract effectively to an umbrella company when they're providing you with workers, and that might be the situation where you would need to check what you've actually got. Is that umbrella company operating pay as you earn and national insurance, or is it assuming something else applies? If the agency hasn't also checked it, then there could be liabilities that pass up the chain. So you may engage with a umbrella company yourself, and if you do that, then obviously that's where the liability might shift to you as a joint liability from April 26. So again, as I say, it's really important that you check what kind of entities you've got in your labour supply chain and how and who is operating tax and national insurance. So I can now move on to the next slide, please. So what else have we got in relation to changes potentially? Well, HMRC are now cross-matching data more easily using their systems. So you might find that whereas in the past you haven't had reviews over status for some time, that actually they are increasingly now reviewing status and the different aspects of status. The requirement is to have much more visibility over your labour supply chains and understand exactly what you have in your labour supply chain. And who is operating tax and national insurance or not, and is that correct? We also have legislation which now has been brought in relation to potential fraud in labour supply chains. And obviously, if you are involved in a labour supply chain which has fraud in it, and you didn't act when there were obvious red flags, then you can find your gross payment status removed under the construction industry scheme for up to 5 years. So that's another penalty on top of the fact that you might also be liable for certain amounts of tax and national insurance. There are also significant penalties that attach to that as well. Normally, however, obviously, if you are having your gross payment status, it would be that if you don't meet the normal compliance tests, then obviously it could be removed for a year. But if it's linked to a labour supply fraud case and you're involved in it and you didn't act on the red flags, then it can be up to 5 years, as I've said. So this is a real big shift and behavioural shift, and HMRC expects active oversight of labour supply chains. So what does this all mean in practice? Have the next slide, please. You should map out your labour supply chains and who is engaged by whom. You should make sure that if you are engaging directly, that you apply employment status tests first and that you clearly document that and have your audit trail appropriately. Also, don't forget to check if the agency rules or the off-payroll working IR35 rules override anything else or override CIS. Only use the construction industry scheme where it's appropriate, so you've definitely got somebody who shouldn't be on a payroll. And as I say, carry out labour supply checks to make sure that actually the right things are happening. And indeed, keep those under regular review because obviously circumstances change. And so that might be quite important. People are actually under checking labour supply chains, asking perhaps for proof that pay as you earn is deducted, but it really is up to you to decide what you think you need. And I wouldn't only rely on potentially information that you might have put in the contract between the parties to say that they need to apply it. You need to actually go one step further. So key takeaways really is the construction industry scheme isn't a safe harbour, and people sometimes feel that it is. I've deducted under CIS, so it's all fine, isn't it? No, employment status sits above that, and it always has done. Obviously, more recently years, we've had different rules, such as the agency and umbrella arrangements, and how now we can end up a situation where you are carrying a shared risk. And we are starting to see increasing activity again in status areas from HMRC in construction, not just in obviously some of the high profile cases that you might have seen previously. So if there's one takeaway from this, is now you're responsible not only for who you engage, but how everyone else in your labour supply chain engages them too. And that's the key to make sure that you understand. So that's all I wanted to cover now. I think it's time for questions.
Well, thank you very, very much, Christy, Susan. Absolutely brilliant, concise and comprehensive overviews of some really complex areas and areas where change seems to be a permanent condition. really, really helpful, and I'm sure that everyone's kind of benefited from that. It's deeply complex stuff. I've got a couple of questions. So one first question from Tim Hayton for Christy. Does the working time regulation relate to directly employed people only? And that's in the context of contractor and interim employees.
I mean, I would be cautious with this because often people aren't necessarily viewed as the employment status that you give them, as Susan's been talking about, obviously. But in terms of the working time records, the new requirements that are brought in by the Employment Rights Act generally relate to annual leave. So going to apply to people that you are giving annual leave to. But bear in mind that that requirement is wider than a standard employee. It goes to worker. So our provisions in terms of employment rights, you have you genuinely self-employed, you have worker in the middle, and then the employees with the most rights. And worker is essentially seen sometimes as a bit of a catch-all. Now, there's been talk of this changing. At the moment, it doesn't seem likely currently, but it was going to relate to workers. So anyone that could fall within that band, or anyone you are paying annual leave, allowing annual leave, that kind of thing, then that's the sensible thing to do, is to include them.
Brilliant. We've got another question from Grant Turton. Is time on standby, is time on standby working time if a time limit is imposed to attend? I hope you understand that, Christy, because
there's a lot in terms of there's a lot of circumstances as to whether time on standby classifies as working time, and there's been a lot of cases in respect of that. So it all depends on what they're being required to do, and exactly what the requirements are, but it's not a straightforward area. There's a lot to it.
Brilliant. Okay, we're coming up to the end of the session, but Susan, I've got a question for you. In terms of CIS, which is obviously, again, it's a complex regime, and you need to be very vigilant in managing that all the time. You stated that employers and businesses need to review their supply chain. I wondered, in that context, could you explain a bit more about what an umbrella company is, its role in the supply chain, and how they can be identified?
Yes, I mean that's can be quite tricky actually, because in effect what we're talking about is somebody who is purporting to provide you with labour that has hopefully deducted tax and national insurance. So the definition in the legislation, which came in April, is actually very wide. So it isn't clear, that you would necessarily know exactly what an umbrella is. You would have to check your labour supply chain and go, is somebody effectively in this chain purporting to deduct tax and national insurance? Actually, are they? And I know that sounds very vague, but we hopefully all know the difference between somebody who's providing us with a service which involves, very simplistically, shall I say, building a wall, and providing somebody who actually builds the wall, to somebody who's just providing the person who builds the wall. And so you can have a situation where an umbrella company is in the supply chain. Normally, what we're talking about is you as an engager, somebody in the middle, and some other company that has been used to effectively deduct potentially tax and national insurance or CIS, depending on what they've been doing. So it's not as clear cut as that. I wish it was, but it's a very wide definition, which means it can capture a multitude of people, which is why the best thing to do is just go, is this business just providing me with labour? And therefore, are there people in the chain between me and them? If there aren't people in the chain between me and them, then do I have any potential liabilities that could transfer to me if they don't deduct tax and national insurance? And if that is the case, then you need to make that you've got some oversight of that so that you're comfortable with it. I don't know if that's helped, Richard.
Unfortunately, I don't have to interpret it, fortunately. It's true, but we've had a follow-up question from Anna already. With HMRC intensifying its scrutiny and certain agency or umbrella set up joint liability, what specific due diligence or auditing processes should we implement to protect our business from a potential transfer of debt if an employment status challenge arises down the supply chain? So that's quite a question.
It's quite a question, and that's what I was saying is you really do need to do due diligence on it, because if they are providing you with labour, then you really do need to understand whether they're treating them as employees and having tax and national insurance deducted. And then the question is, how much do you feel you need from that business to make sure that you are comfortable that that is happening not only at the start of the relationship but ongoing in the relationship. And you may decide that then you need to see pay slips. You may decide that you want to see copies of their payments to HMRC to make sure that it's being paid over. It is up to you, because you potentially hold a risk that you could have a joint liability, to put in place some procedures that give you the comfort that that risk is narrowed. Now, clearly, you may get more comfort from some businesses that are, large scale, well known, and you think everyone else is doing it as well. But it's a risk profile, and you've got to decide how comfortable you are with your risk, and therefore try and put mitigations in to narrow that risk down. So it would depend on the individual organisation. Obviously, again, you can write these things into the contract with the provider, so that you then have the right to see those documents. And I would suggest you do that if that's what you want. To be able to see. But everybody's going to be in the same boat, and I suspect people are going to get used to the fact that if you're trying to check if you potentially could have a liability, you're going to be asking for documents that you wouldn't have previously asked for, just to prove that liabilities have been paid over to HMRC, either pay slips where the individuals have had the deductions, but you may also want to actually see that they've actually paid that money to HMRC as well, not just deducted it and kept it.
Fantastic. That's absolutely wonderful. Look, all that remains, we're at the end of the session. There's a question from Rob Edis that I might ask Christy to kind of provide me with an email response for, and I'll pass on to Rob. Nice to see you, Rob. But we've come to the break point. Thank you very, very much, both of you. It's been an absolutely brilliant session. We're going to have a 10-minute refreshment break. So if people could be back with us at, let's say, 18 minutes past 11, to be really precise about it. But Susan, Christy, thank you ever so much. It's been fantastic. And for everyone else, I hope to see you after the 10-minute break.
Thank you.
Hello. Hopefully everyone is back in the room. Welcome back to you all. We're about to move on to our third session this morning. I hope you enjoyed the first two sessions. I think they were both absolutely great. Our third session is on professional indemnity insurance and risk allocation. And I'm absolutely delighted to be able to welcome Tim Grant, who's a divisional director at Howden Insurance Brokers Limited. And Howden's are our insurance partner, and we work very closely to identify opportunities to improve provision for our members. And Rachel Murray-Smith, who's a partner at Sharp Pritchard. So without further ado, I'm going to hand over to Tim.
Thanks, Richard. Hi, everyone. Good morning. As Richard said, I work at Howden Insurance Brokers. We are kind of all-encompassing insurance broker, but my specialism is within the professional indemnity world. I've been involved heavily in this for the last 18 years, so I've seen the built environment. I'm here today basically to talk about what I call a common sense approach to managing risk, and that's how you manage it through the use of insurance, and some tips on what you can look to do on a day-to-day basis to help manage that. So we could go to the next slide and the next one again, please. Perfect, thank you. So the first one is, what is professional indemnity and why is it important? Many of you will purchase professional indemnity. It's actually an insurance policy you buy to cover you in the event of an actual or an alleged wrongful act that has arisen in the course of your professional business or professional services that you've provided to a third party. And the allegation is that this negligent act has caused a financial loss to said persons. Now, one of the important things about professional indemnity is not only does it protect you if you've been negligent, it protects you to defend yourself if you haven't. And defence costs are a really important part of a professional indemnity policy. And one of the first things I always ask my clients to look at is to look at the PI policy as kind of risk mitigation to your balance sheet and to yourselves, because the costs of defending contractual disputes can be incredibly expensive. It's an evolving litigation landscape we find ourselves in. Obviously, there's a large contractual obligation where most people have to carry professional indemnity insurance now, or it's a requirement of a regulatory body. But it also gives confidence to the clients and to the parties you work with that if anything were to go wrong, they're not going to be out of pocket. And we are seeing the requirement for professional indemnity has increased, and the limits that are being asked to carry have increased. I don't necessarily agree with some of the requests we get. I had one the other day where somebody was designing a bus shelter outside of a hospital, and they were asked to carry a £10 million limit, which seems obscene. It acts as a barrier to protect your reputation as a company as well. It allows you to keep trading. The cost of these claims, as I said, could be fairly substantial. You want to be able to continue your day-to-day work where you have specialists defending you. And that's one of the key things that professional indemnity does. And I think the key point I would like everybody to take away from this is, instead of looking at professional indemnity as an insurance purchase, look at it as a mechanism to transfer risk from yourself to insurers. People often say, I don't need professional indemnity, I don't want it. But actually, we all have an exposure when we're providing professional advice, design, supervision to a third party. And it's not uncommon to become entangled in a contractual dispute, even if it has nothing to do with you. So the PI protects your balance sheet and it protects your own personal wealth. Because ultimately, if the PI isn't there and it can't pay to defend a claim, it's going to be the company assets, the company balance sheet, or potentially your own kind of personal wealth that's going to have to pay for that. Can we get to the next slide, please? So what's good to often go over is, where is the professional indemnity market? Often, you approach a broker for professional indemnity quote and you'll just be given your terms. They may go up, they may go down, but you may not actually be aware of, what's happening in the market, trends that we're seeing, and as we'll come on to in a minute, maybe new changes from a regulation perspective that are impacting the market as a whole. So currently we are in what we call a soft market in the professional indemnity scene. Back in 2019 to 2012, post Grenfell, we saw a huge surge in premium costs for those in the built environment, as well as an increase in costs. We saw a real reduction in policy coverage. I'm glad to say that since then we've been on a downward curve. Premiums now are probably at the most competitive I've seen, definitely in the last probably 15 years. And we are seeing premium reductions for everybody who is, involved. Please come on my phone and enable things. We are seeing broader policy coverage available. So we are seeing the addition of kind of fire safety and combustibility coverage being included back now. The coverage available will depend on the insurer you're with and potentially the type of work that you're undertaking. But the minimum coverage that we're seeing now is, coverage back to potentially 2019 and the costs of covering, rectification and reperformance costs of the work undertaken. It is possible to extend that now. We have placed risks where full fire safety coverage is included. So that would include, coverage for consequential loss or any other cost that could be associated to it. So it's important that you are exploring what is available to you in the market and also taking advantage of where the market is now. Insurers are taking really keen risk on how businesses are approaching their risk and managing risk. Although we are in a soft market and premiums are very competitive, some insurers are being incredibly selective in the risks that they write. Insurers are, ultimately actuaries. They're looking at your risk, they're looking at how much they want to charge for that and the probability of you having a claim. They have to take in enough money to cover costs and claims. So they are trying to pick the risks they deem to be maybe slightly less risky, or the risks that are more within their appetite. So one thing that I would urge everyone to do if you're looking at your professional indemnity renewal is to really give them an insight into how you manage risk. One of the key trends we're seeing at the moment is the use of AI and emerging technology. I'd say this is the first year insurers are maybe specifically asking questions or becoming particularly interested in how the technology that you're using impacts your day-to-day business, and how, if you're utilizing AI, you're using that in a sensible way. We are seeing questions around policies internally around the use of AI. If you have staff, how are you monitoring their use of AI? And also, if you're using it as part of your professional service, how are you ensuring that the information that comes back from that is suitable and correct. Ultimately, the advice that you're giving to the client is deemed to come from you, even if it's come from AI. So if there is a mistake in the information that you've got from AI and you haven't checked it properly, you could still be liable for a PI claim. We are seeing an increase in the severity of claims, possibly the number of claims we see, not necessarily the amount which is successful. There is a trend that when economical pressures are greater, we do see an increased claims frequency. And this is just generally because people are looking to pursue recovery actions, pursue money where they can. The cost of materials has gone up, the cost of living has gone up. When there is a claim, it is substantially more these days. And prepare for the hard market. I mentioned earlier that we are currently in what I call a soft market, but there are signs that a hard market is coming to us. What this means is that we will slowly in the future see an upward curve in relation to premiums, in relation to the availability of cover, and insurers who are interested in quoting for professional indemnity insurance. When we hit a hard market, we do see a reduction in the number of insurers who will quote. My best advice would be start planning for the hard market now. Look at your coverage, obtain additional coverage where you can. It's harder to lose it when you've already got it. And look at how you manage risk. Is there anything else that you could implement, contractually or from a risk management perspective that you can put in place now that when, the ability to obtain cover becomes slightly more difficult, we're able to illustrate to insurers why you're a better risk. Could we go to the next slide, please? So one thing that I'm keen to maybe just discuss is the impacts of the Building Safety Act and then the changes to the Defective Premises Act and how this had an impact on the professional indemnity market. Obviously, the Building Safety Act will be applicable to most people on this call and within the built environment. And it has seen a shift in the insurance landscape and specifically professional indemnity. We're yet to see the full impact of what this may do to the PI market. We're still waiting for claims to go through court. Case law tends to lead what insurers do. But the building safety regulator now being in charge of the broader building control regulation has meant the stricter regulations are going to be put on those in the built environment. This will lead to additional claims. This will lead to claims from the regulator. This will lead to claims from clients, and is something that insurers are really wary of. The Building Safety Act has extended the Defective Premises Act liability period. So anything for work which was, I've got those the wrong way around. Anything for work undertaken pre-2022, we've now got a 30-year liability period, and there's a 15-year liability period for anything after 2022. This will mean that insurers now face a longer exposure to claims. Where before liability period was potentially capped at 6 or 12 years, potentially 15 years under the Latent Defects Act, it does mean that claims can come from projects that were completed 20, 25 years ago. This is potentially going to cause problems for insurers because not many firms will have all of the documentation from that time, from all those years ago. The introduction of the Building Safety Principal Designer role has introduced new obligations to those who undertake this role. Usually it's architects who are undertaking this work, but it does mean that there is now a wider scope of emphasis on them to ensure that the work and specifically the design that's undertaken by others is correct. There's an onus on them potentially to warn of an error in others' design, and where there is additional liability upon a professional, it will always mean there is the chance of increased professional indemnity claims. The introduction of the building liability order means that potentially companies, developers, or associated individuals can now be held liable for remediation costs. Historically, companies would go insolvent or close themselves down and say, we're unable to meet these costs. There is now ability for the regulator and governing bodies to chase these parties. This will, in some cases, lead to professional indemnity claims, and of course, when we see more claims, we potentially see an increase in costs. Would you be able to go to the next slide, please? So allocation of risk, how do you protect yourselves? So as an insurance broker, we can only look to provide advice from an insurance perspective. We can never give legal advice, but there are some things that, we would suggest you could do to help limit your own liability. So the first and one of the key ones is to actually look at the contractual terms and appointment documents that you are asked to enter. We do say that check the liability that's being put forward to you is in sync with the activities and the work that you're undertaking. So, are you being asked to enter into an agreement which is giving you a level of liability which meets the professional services you're providing? Insist on a clear scope of works for the services you provide. And this is one thing that, when we're reviewing contracts, we don't often see. We like to see a clear contractual clause which says you have been appointed to undertake X, Y, and Z services, and this meets with the services that you've been provided. If there is a claim, a lot of it can come back to did you meet the scope of works that you were asked to provide? And if it isn't clear as to what this was, it can cause issues. Do your contractual obligations invalidate your ability to benefit from the professional indemnity policy? And this is something which people often overlook, specifically if they're not looking at it from an insurance perspective. There are certain clauses or certain levels of liability which you may accept under a PI policy, which could invalidate your professional indemnity insurance. A key example of this is agreeing to a contractual liability clause, which provides liability that would have been greater than would have existed if you hadn't entered into the contract. The use of reasonable skill and care is expected, but what level of reasonable skill and care are they asking you to agree to? If it is above that which is, already in place and would have otherwise existed, we would say you need to push back on this. Are you appointing third parties? If you are, then be wary of that. Ultimately, if the third party goes bust or isn't able to meet a claim, the liability will sit with you. So do your due diligence on them. Do your credit checks, do some historical checks of people they've worked for, check that they have the suitable experience. Specifically, if you're taking on the principal designer role, you really need to ensure that there is competency for those involved in the chain that you are responsible for. Where possible, look to limit your liability. If you can put in a limitation of liability clause, then please do. Be aware that the clause needs to be proportionate to the work undertaken. So you can't just put in, a £10,000 liability cap and think that's going to be fine. But be sensible when looking at this and negotiate it if possible where you can with your clients. The next point I think is one which is fairly obvious, but sometimes people overlook. It's only take on work which you're competent and confident to undertake and that you can deliver to the needed level. Sometimes we will see people dabbling in projects, maybe in work they haven't undertaken before, and this can ultimately lead to claims. Identify and manage risks on projects. Detailed notes, file notes, clear correspondence to yourself and everybody else on the site is really key. Ultimately, if you have a PI claim, you need to be able to defend it. If we don't have a clear admin trail, if we do not have a clear set of who was responsible for what on a project, it becomes incredibly hard to be able to defend you. And again, one of the points that I want to come on to is something that I discussed earlier, is transfer risk to insurers through the purchasing of insurance. This doesn't just mean buying insurance. This means looking at what type of insurance you buy, the level of insurance you buy in regards to limits, and also the scope of policy coverage you have. A cheap policy is good to get on site, but ultimately, if you need that to react, it may not actually meet what you need it to do. Do check the policy terms and conditions, do ask the broker several questions about what it does and doesn't cover, and do get a range of quotes. Could we get to the next slide, please? Policy coverage, do you know what you are or do you know what you're not covered for? The widest breadth of policy coverage you can get is a legal or civil liability based policy. So it will cover things which you are legally or civilly liable for. There is a more limited scope of cover, which is an errors and omissions based policy. This means that claims must come strictly from a negligent error or omission in the course of your professional business. We would always say try to take a legal or civil liability policy where possible. Does the policy exclude or limit coverage in relation to fire safety and combustibility claims? This is something that is readily available in the market now. We are in the built environment. It is something which should be on everyone's radars. Even if there is not direct responsibility there, you may potentially have a vicarious liability which you need to defend. Inner limits, does your policy cover pollution and asbestos related claims? It may not be directly responsible to you, but it may actually be an obligation within your contractual agreement that you carry this cover. Does the policy provide coverage for criminal prosecution defence costs? Obviously, the BSR are able to chase duty holders personally for breaches of the Building Safety Act, You need to be able to defend yourself. A good PI policy should cover you for the costs of defending yourself in an investigation. And notification of claims. Are there any specific notification clauses which need to be adhered to? If we could just go to the next clause, I'll touch on claims quickly, and then I will. Sorry, just go to the next one, please. And then I'll pass over to Rachel. Claims and notifications is something we often get questions from clients on, or potentially they have issues with. And there's a few things that you can do to leave yourself in the best position when it comes to a PI claim. Claims notifications are on the rise due to economical pressures. You buy PI to cover you for potential claims. Use it. Don't shy away from it. Some policies are written on a may give rise basis. Some are written on a likely to give rise basis. And there is a difference here between when you notify. On a may give rise basis, it sets a low threshold. There does not have to be certain negligence to apply for you to have to notify insurers. Where it's written on a likely to give rise, it means there has to be at least a 50% chance of a claim materializing. My best advice for this is speak with your broker. You're using a professional for a reason. If there is a grumble, it's better to be safe than sorry. Call your broker, discuss the situation, and ask them what you think needs to be done. And they should be able to give you the guidance. Failure to follow the policy notification clauses can lead to a PI insurance, declining a claim. So please be wary. And please never admit liability. Even if you know that you've made a mistake, you are not supposed to admit liability, as it may prejudice your position to cover under a PI policy. Then the last point, please work with your broker, be prompt with responses. They may ask for a lot of information, but it's needed for them and the insurers to correctly cover you. But I don't think there's any more slides for me after this. I think that's my last point. I'm now going to pass over to Rachel, if that's okay, and I will let her continue from here.
Thank you, Tim. And apologies for disrupting your flow by asking if someone could turn my camera and mic on. Apologies for that. So I think neatly fitting into what Tim has covered in his part of the session, I'm now going to talk about risk allocation more generally. So hopefully if we can move on to the next bit of the deck. Some animations to get through first, and then if we could go to the next slide, please. Thank you very much. So I am a non-contentious construction lawyer in the main, but I think as Tim put it, and perhaps I shouldn't admit this, I would what I refer to dabble in contentious work, but in all seriousness, I do a mix of non-contentious and contentious, and I think that frames this discussion quite nicely, because I'm both responsible for drafting appropriate risk allocations within contracts, and then also responsible in certain circumstances for dealing with the fallout where, for whatever reason, that hasn't been achieved. So as we know, there are a myriad of risks within the industry that have been added to by the increase in regulation that Tim referred to, but also more recently things like the conflict in the Middle East. And I just wanted to start my part of the session by slightly going back to basics when it comes to risk allocation. So whilst a public sector tool, the construction playbook provides a kind of one-stop shop of industry-wide relevant principles in relation to risk allocation and management. And the principles set out on this slide are borrowed from that playbook. The playbook is aimed at commercial, finance, project delivery, policy, and other professionals across mainly the public sector sphere, who are responsible for planning and delivery of works, projects, and programs. Those principles and policies have been co-developed with input from public officials and industry stakeholders, and I think it's fair to say they can be considered good practice for all professionals involved in works, projects, and programs, both in the public but also in the private sector. So in terms of those sort of foundational principles, they're up on the slide. So we start with risk should be allocated to the party best able to manage it, control it, and bear its consequences. So following Tim's session, it should be noted that this principle also encompasses the fact that it should sit with the party best placed to absorb or insure against the specific consequences of that risk. So many of you will know that there is often not a literal application of this principle in contract negotiation and finalisation. And instead, I think it should be viewed more as a kind of benchmark for fairness and bankability and insurability of those provisions, and not necessarily a strict rule. Where that principle is departed from, for whatever reason, those departures from that sort of principle should be consciously made, as opposed to accidentally provided for as the result of drift in drafting or scope. And such departures should also be priced for appropriately. And as already mentioned, due consideration should be given to how those departures are covered within any relevant insurance. The second principle is that risk allocation proposals must be informed by genuine, meaningful early engagement with the market. We know that inappropriate risk allocation is recognised as a kind of recurring supplier concern, a deterrent to bidding for public sector contracts in particular, but that risk allocation should be scrutinised before going to market and not left to kind of contract drafting late in the process. And as I say, whilst these principles are set in a public sector context, I think they're equally applicable to the private sector. So irrespective of how you place your contracts, whether that be by way of a competitive public tender or otherwise, the principle is that you should be giving due consideration to your risk allocation decisions. It's important to review and revisit. You should be challenging your rationale and reframing your allocation if and as necessary. So as I mentioned at the top of the session, there can be emerging risks and you need to revisit and rethink, have I got this right? Do I know how that risk would be treated in respect of my specific contractual suite? Allocation decisions must take account of the practical capability to manage risk and also financial capacity to absorb the risk if it materialises. The playbook references unlimited liability expectations, which it discourages, except in very narrow justified circumstances. It's commonplace and entirely market standard, both in respect of professional construction consultant appointments and work contracts, for liability to be capped. The precise mechanics of that cap do need to be carefully considered and should be driven by the nature, complexity, value and scope of the particular contract in question. And I think too often caps are approached from a more simplistic sort of monetary perspective, without appropriate recognition being given for the kind of differing nature and types of risk and loss. And then finally, contracts should be profitable. So there should be fair returns and expectations, and they need to be reasonable for the suppliers to remain interested and for ultimately the market to remain sustainable. I think we can probably all agree that over-aggressive risk transfer is invariably linked to poorer outcomes. We've seen insolvency within the industry and reduced competition over time. However, this principle and its application, I personally think, needs to be underpinned by transparency between the parties. And there needs to be a holistic project-based approach and mindset from the outset and continuing throughout. As I mentioned at the top of my part of the session, and as Tim has also referenced, there is additional regulation within the sector, and that has become a key risk to be considered and allocated, particularly within professional appointments when we're thinking about it from a design perspective. So, for example, if you're involved in the design and construction of a high-risk building, some of the important component parts of that risk allocation will be who's been appointed as duty holders. There is some debate in certain circumstances about who should be appointed into the BRPD role, for example, and the codification of that duty holder role and responsibilities, needing to think about competency on an ongoing basis and also insurance considerations. How do you capture the obligations of those duty holders? In so doing, it's important to recognise the overarching requirement for information sharing, the client's roles and responsibilities, and also time and quality of outputs. And then finally, dealing with compliance and program risks. So ongoing competency requirements, as I mentioned, the flow down of that through a supply chain, but also the program risk. Now, we know that the BSR has taken steps to address some of the delays in the gateway process, for example, but they are not resolved in their entirety. And so due consideration needs to be given how to best manage the risk of delay, both prior to the commencement of works, but also at completion and prior to occupation. Next slide, please. Thank you. So I just wanted to take a look at a couple of the key standard form construction suites and how they deal with risk allocation. So we will be looking at NEC and JCT respectively. I'm not getting down into the kind of weeds and the detail of this given the time available today, so it is more broad brush, but nevertheless, if you've got specific questions on either of these suites, happy to pick those up in the Q&A. So in terms of the NEC, I think it's fair to say that the behavioural obligations are embedded into risk allocation. The forms encourage openness rather than defensive positions. The programme becomes a key risk allocation instrument, not just a record of what might have happened within a project. Commercial risk is intentionally adjustable depending on what option you use, and there is no single kind of risk optional position. Risk is identified, shared and managed early rather than debating it as it materialises. So there's kind of a codification of that joint management of risk, particularly in an option C environment. There's that kind of collective responsibility / liability for commercial impacts. And I think in summary, there's a strong alignment probably with the construction playbook philosophy and principles. And I think what I would say is that the NEC is widely accepted that I think the success or failure of that particular methodology is heavily reliant on good quality management, which can be resource intensive. And then the JCT, which is often viewed as the kind of more traditional approach to risk allocation. We have the 2024 suite, which was published. One of the items that was dealt with as part of that 2024 republication was the move of the optional collaborative working provisions into the main conditions. It's worth noting that no substantive drafting changes were made to those provisions, and so I think it's probably best described as a kind of light touch approach to that collaboration piece. The moving of those collaboration provisions hasn't, for example, been accompanied by kind of structural contractual mechanisms being included. And I think it's probably, again, fair to say that the JCT is still based on a reactive rather than proactive, or retrospective rather than prospective way of managing risk. The JCT suite invariably still provides for an all-in pricing, although it is notable that they have released a target cost form of contract. But again, it doesn't adopt across things like the risk register or risk allocation schedule that you might see in the constructing excellence form from that suite. And then just picking up on some comments from Tim's session, the JCT 2024 suite provides for the setting out of exclusions to insurance policies. And I think that's helpful to identify and explicitly address those and identify them up front. I mean, cladding and fire safety have been common exclusions, but it sounds as though the insurance market may be softening on those. In terms of the D&B and other design forms, the contractor takes primary risk for design, and we'll get into a little bit about the standard for design in a moment. But the employer takes responsibility for errors and inconsistencies in the ERs, kind of baselining their risk there, although it should be noted that that position is often amended to create a single point of design responsibility. And then finally, as a kind of segue into my next slide, the 2024 has introduced a specific exclusion of fitness for purpose. This comes out of the MT Hoggard and Eon case, and arguably shifts risk share in favour of the contractor, although I'm sure Tim would just say that it's supporting the appropriate and insured position when it comes to design risk. So that moves neatly into my next slide, please. So I think it's helpful to look at the MT Hoggard case. I think it's a prime example of needing to ensure clarity and certainty of risk allocation. And as I've just touched on the JCT form, it's worth mentioning that it was a JCT form of contract that was in question here. So MTH were engaged by E.ON to design, manufacture and install foundation structures for 60 offshore wind turbines for the Robin Rig wind farm in Solway Firth in Scotland. As probably many of you know, the foundations of the wind farm failed and the cost of the remedial works was approximately £26.2 million. So the contract included various references to a design life obligation. Notably, each were worded slightly differently, and I'm just going to give you some examples of the wording. So there was reference to the works being designed for a minimum site-specific design life of 20 years without major retrofits or refurbishments, all elements to be designed to operate safely and reliably in the environmental conditions that exist on site for at least this lifetime. Separately, there was reference to design of the foundations to ensure a lifetime of 20 years in every aspect without planned replacement. Then again, it referred to parts of the works, except where parts of consumables shall be designed for a minimum service life of 20 years. And then separately, that the design of the foundations was to be in accordance with an international standard, DNV OS J101, or as I'll refer to it, J101, and that standard was intended to deliver a service life of 20 years. So in 2012, MTH applied for declarations as to the cost of the remedial works and who should bear that cost, claiming that it had exercised reasonable skill and care and complied with all its contractual obligations. E.ON claimed that there were numerous breaches of contract by MTH and counterclaimed for declarations to the effect that MTH were liable for the defective works. In April 2024, the first ruling went against MTH, but the company filed an appeal. The Court of Appeal reversed that first ruling in favour of MTH in April 2015. The court upheld MTH's appeal on the basis that the contract only required the foundations have a design life of 20 years, meaning that they would probably, but not necessarily, function for 20 years. E.ON appealed that decision, claiming that the contract imposed a fitness for purpose obligation on MTH, amounting to a warranty that the foundations would have a service life of 20 years. And in addition, that it was the responsibility of MTH to identify any areas where works would need to be designed to any additional, more rigorous requirements or parameters. So if we can move to the next slide, we'll get to the decision. Thank you. So it was decided that the contract contained dual obligations. So to exercise reasonable skill and care and comply with J101, but also to ensure the foundations would last 20 years. The 20-year design life requirement was an absolute obligation, i.e. an FFP, not merely a standard of care. Compliance with J101 did not override that absolute or FFP obligation. So where obligations appear inconsistent, then the court will try and read them together, but a clear FFP obligation prevails, as it did in this case, even if it requires more than compliance with specified standards. It's worth noting that the relevant design life wording, and I've given you some examples of how that was referenced, was tucked into the technical schedules, but was still found to be contractually binding. And the contractor was found liable for failing to achieve a specified result, even though they'd complied with the employer's prescribed standards. The main takeaway here in the context of my session today is that it's absolutely essential to strive for consistency within your appointments and contracts, and to do so based upon the entire suite of the contract. So that is the technical and commercial documents as well as the front end. So next slide, please. Just to finish up, and conscious of time to allow for a little bit of Q&A, the key takeaways in terms of risk allocation is that it should start early along with the management of those risks. It should appear from the outset of the project and commercial life cycle and continue throughout. It's beneficial to adopt a joint and collaborative approach to those risks. how those risks are allocated should account for both the practical capability and the financial capacity of the relevant parties to manage and absorb the risk. Any allocation should be supported by good risk management, which should be aligned to the project and programme outcomes. Ensure alignment throughout your documents to reflect that agreed position. And it goes without saying, but I'll say it anyway, that misallocation or uncertainty in risk allocation invariably results in inflated pricing, disputes, and uninsured positions. And I think I'm going to hand back now for a bit of Q&A.
Fantastic. Thank you very much, Rachel. Thank you very much, Tim. Absolutely brilliant. We've had quite a few questions within that. I see Tim's been very busy answering them in the chat, which we absolutely love. When we did our Scotland event at the start of the year, the members were answering each other's questions before I could get to them, which was a massive workload reduction on my part. But okay, let's have a quick look at where we get to with this. So we've got kind of 10 minutes or so for questions. Question from Rob Edis first. Rob missed out last time round, so I've bumped him up to the top of the queue. Can PII premiums or cover be affected by whether or not the building regulation principal designer duty holders use a building notice or initial notice without the principal contractor, given the lack of detailed design approval with those application routes?
That's a question. I wouldn't say PI premiums are going to be affected. What I would say is you would look, from my perspective, look to see how much risk you want to take on as a company. So obviously there are, and Richard, you may be able to give more of an insight on this because I haven't done that role. But from a PI perspective, we're looking at the risk you take on, and are you suitably qualified or experienced to be able to make that decision without maybe the say-so or the input of other professionals on the project. So I wouldn't say it's going to impact your PI, but I would say from a risk management perspective, is that a risk that you want to take? Because ultimately, if a claim did come from that, it's going to fall with you because you've made the decision to push on with that.
I mean, if you're a genuine principal designer, rather than just what might be referred to as an accidental principal designer, i.e. the person on whom that responsibility falls, I think using building notice is convenient, but perhaps not a particularly good idea. So I think absolutely, it's about it's not the premiums, but the level of risk and exposure. A second question for you, Tim, from Veronica Fury, who's one of our current vice presidents. Yep. Hello, Veronica. In relation to under the Defective Premises Act 1972, the government extended the time limit for bringing claims to 30 years for defective work completed before June 28, 2022. For works completed after June 28, 2022, the limitation period is set at 15 years. What are the implications to the insured professional from the moment they stop trading, i.e. due to retirement or bankruptcy?
Right, good question. And this is one that we're having a lot. So usually when you stop undertaking your professional activities, this could be retirement, it could be bankruptcy, it could be moving from limited company back into employment, there is a tail liability that needs to be covered. Now, usually this is covered by the way of runoff insurance, which you will purchase, which basically says that any liability undertaken prior to the date that you cease to trade will be covered under a PI policy. This is usually purchased for anything up to 6 years. And 6 years is generally where we settle. Obviously, with the extended liability periods, it is creating a potential issue for those who've undertaken the work as to how long they carry runoff insurance for, because obviously the limitation periods have been increased. Now, the wide limitation periods have always been there in one form or another. So the Latent Defect Act could push liability periods back to 15 years. So there is no hard and fast rule on this, if I'm being perfectly honest. We would always say you need to take runoff cover. There is case law to chase individuals personally if they close down limited companies or other companies where they've not took the insurance. But we'd say a minimum of 6 years, and anything longer than that becomes, I guess, more of a personal decision on how liable you feel. Not that useful, I know, but we're kind of venturing into new territory here with the extended limitation period. So we've not seen it tested yet.
Okay. It all will become clear perhaps over time, unfortunately.
I think so, unfortunately. Sorry.
Question for you again, Tim, from Rob Gary. I understand the advice regarding investigation differs for an RBI, particularly when employed. If an employer has PII insurance, this will protect them from financial risk, but a complaint to the BSR does not protect an individual RBI against regulatory consequences or the costs in defending against the BSR investigation, albeit that an employer might support a defence. Is Rob's understanding correct?
It is, and this, ironically, it's a conversation that me and Richard have had many a time. So you are correct. So there is no obligation from an employer to indemnify you or provide costs if the building safety regulator decides to, personally go after an individual for the breach of, the duty holder regime, etc. So at the moment, technically, you are left to foot that cost yourself. And I think it's something we're very aware of because you're deemed to be an employee. Some businesses will have what we call directors and officers insurance policy in place, which would cover the costs of regulatory investigations, but that generally goes to directors and senior officers, and it doesn't cover you if you leave a company. The good news is we're actually looking at a way of potentially offering some sort of support or coverage to those individuals in the situation that Robert has actually put forward. And what would be good in the near future is to get an idea of actually who would be interested in that sort of cover.
That's something we're going to look at, I think, isn't it, Tim? Because we can see that there's that gap there where offering some protection might be really beneficial. Yeah. Rachel, question from Duncan Hogg, I think for you, quite a broad one. We work with the Department of Education, and their requirements often refer to minimum life expectancy. Should we be concerned?
So I'm going to give a typical lawyer's answer to that, which is that it depends. So I think first and foremost, as I mentioned in my session, knowledge of the risk that you're accepting is absolutely critical. So I think it's essential that you review what I would refer to as the risk matrix or the package of risk that is being placed upon you as part of that contract. So if you weren't aware that that was transferring a risk to you previously, then perhaps you may be a little concerned and want to kind of revisit the wording. But I think whether you should ultimately be concerned about this essentially placing an FFP obligation on you will depend on what the front end of that contract says. So that may include wording that expressly excludes that obligation, for example. So I think it's probably time to just have a little revisit. But this goes to the point of needing to have absolute clarity and awareness when you enter into an arrangement of what risks are placed where. That is first and foremost, and I think that's the benefit to all parties to that arrangement, to be clear on how those risks will be dealt with should something arise during the course of that project or thereafter.
Brilliant. And then a final question to you, Rachel, from me. Is there any evidence of the extent to which collaborative contracts such as NEC reduce risk? And if you were choosing a contract likely to minimize your risk, which contract would you choose? A little bit of a cheeky question, but
I was going to say I might plead the fifth on the second part of that question. So in terms of the first part, I think there is a body of kind of academic research which is supportive of that collaborative approach, and certainly from a central government perspective, the kind of onus and support is behind those more collaborative forms. I think that the difficulty is that the reasons for the success are often more complicated or complex than just the form itself. And it's actually about whether the approach has been fully embedded within the organisations that are a part of that contract, and whether, as I mentioned in my session, they're properly resourced. That's such a large factor in whether that's actually a successful approach, and also that openness and transparency is absolutely critical to the kind of trust and oversight of that sort of process. On the second, I'm not sure there is a single form. I increasingly look at those forms in a more holistic sense and regularly borrow parts that I like from different forms to create what I think is a balanced position, but entirely driven by the specific project in question and, of course, the outcomes that my particular instructing client is seeking to achieve.
Fantastic. Well, look, That brings us to the end of that session. I just want to say absolutely fantastic. Thank you very much. Two great presentations. Thank you, Rachel. Thank you, Tim. And we'll move on to our final session. I'm delighted to welcome Martin Burns, Head of Alternative Dispute Resolution Research and Development at the RICS Dispute Resolution Service. Alternative dispute resolution is absolutely fundamental to save time, cost, and maintain relationships. In a strange way, we are segueing from a discussion about litigation into how to avoid it. But these are all realities of the world we live in. And I'm really happy to hand over to Martin to take us on a kind of refresher journey and to provide some kind of key insights into where we are with alternative dispute resolution at the current time. So over to you, Martin.
Thank you very much, Richard. I wasn't quite sure how to pitch this presentation on an ADR, and in fact I put a lot of slides together, and like any sensible person, I asked Richard, how long do you want me to speak for? And he said somewhere between half an hour, 45 minutes, leave some room for questions. So again, like a sensible person, I rehearsed this presentation yesterday evening, and I rattled through it in an hour and 3/4. So we'll see how we get on. I just hope you haven't got anything planned for this afternoon. The presentation is on ADR. Can we have the next slide, please? And my approach has been very light touch. I just want to cover quite a lot in a very short period of time with these slides. But I think context is important. And the context is, you know, where does ADR fit in? Why is ADR important? And I've worked in the area of dispute resolution for RICS for 36 years. And I'm currently head of ADR research and development there. And I work with a lot of government institutions, industry bodies, in trying to help them avoid, manage and resolve disputes without the necessity for going to court. One of those barristers, I'm afraid, that other barristers despise, because I often say, please don't go to barristers or other lawyers. In terms of context, the costs of disputes in the construction engineering sector are enormous, and not just financial. They cause all sorts of problems in terms of they distract people from doing their core tasks in the day. They add significant delays to projects, and of course they also reduce we've just had a very interesting discussion around insurance, and they reduce the availability of project insurance. Next slide, please. If you really want to get a real sense of the size of the problem disputes, then I can recommend to you the HKA Consultancy's annual report. If you haven't seen it, it's their insight report on global disputes, the HKA Crux report. And if you read through that, some of the statistics are indeed eye-watering, and indeed eye-watering is a word that they use, and they're descriptive of global disputes. And though this was a global exercise in terms of their evaluation of the problems that disputes cause in the industry, there is sections on particular geographical areas. And the UK doesn't come off lightly. The UK is just as bad as everywhere else in terms of the descriptive is very much around that the industry itself is geared towards disputes. So against this, we're looking at how can disputes be resolved, how can they be managed, and indeed, can they be avoided? And usually I'm going to go to the avoidance bit right at the end of this. Next slide, please. What is ADR? Many of the lawyers I've talked to often synonymize ADR with mediation. But ADR is actually a whole raft of different measures and methodologies and techniques that can be used to avoid, manage, and resolve disputes. ADR is defined in law. When I say that, it's actually defined in the civil procedure rules, which are the rules which regulate the civil litigation process. Defined there as any method for resolving a dispute that means you don't end up in court. So it's an alternative to the courts. It's encouraged here in the UK, it's encouraged outside of the UK. Parties actually obliged in UK law to avoid ending up in court if they can. And the courts indeed have power to penalise parties if they feel that they've ended up in court unnecessarily and haven't appropriately adopted a form of ADR or used ADR. And the courts, of course, can order parties to use ADR. And I've referenced the leading judgment there in the Court of Appeal and November 24, Churchill Merthyr Tydfil. In that particular case, the courts made it very clear that judges have power to stay legal proceedings and order parties to go and adopt a form of ADR rather than litigate their disputes, or at least do so before they litigate. Next slide, please. I mentioned that ADR is not simply mediation, that it's a whole raft of different mechanisms. And this is a slide I actually used recently for students at built environment students at the University of Westminster. And what I wanted them to do is to get a sense of ADR as a whole spectrum of different types of measures that can be used and utilized for different types of disputes, different environments. And this is not that entire list. This is just a list of different forms of ADR. And what I've asked the students in that lecture I gave is, which one of those is an odd one out? There is one that's an odd one out. Now, we haven't got time here. As I say, we've got to rattle through this. But if you just look at these for a moment and just maybe ponder, one of those measures or methodologies is unusual compared to the rest. Next slide, please. It's negotiation. And the reason I give, in fact, I've asked students on many occasions to tell me which one they think is the right one, and they've never, ever got it right. And because they've never got it right, they've never actually been able to explain why it's negotiation. The fact is, negotiation is the only one of those methodologies that doesn't involve a third person coming in and either deciding the dispute or helping to facilitate a resolution of a dispute. Negotiation is a very effective means of resolving disputes, and it's by far the most sensible way of resolving the disputes. It doesn't involve a third party intervening, so you don't have that additional cost. It's simply the two sides getting together and finding a solution between themselves. Next slide, please. A few words about negotiation then. It's simply a non-binding process. It's by far the most common way of resolving disputes. So I've often talked to professionals in the construction industry who say to me, I've never been involved in a dispute. And the reason they give is that they often negotiate. They talk their way to a resolution, which is brilliant. Of course, it doesn't always happen, because otherwise I wouldn't be doing the job I've been doing for the last 36 years. Next slide, please. Clearly, benefits of negotiation. Can we go back one? Benefits of negotiation, it's flexible and formal. You compare to court proceedings, which are very formal, have a language of their own, have very strict rules, timescales, and you have to be where you have to be in order to have your case heard. Negotiation has none of that. It's very flexible, very informal. It can be undertaken on a without prejudice basis, which means that whatever is said in the negotiation stays in the negotiation, can't be used against you at a later date if you end up in court. And of course, the commercial parties themselves have control over the outcome. It's not left in the hands of lawyers or a judge or an arbitrator or adjudicator. They decide what the outcome is going to be. And of course, that outcome itself can be confidential. Next slide, please. Think about negotiation is you can actually be taught skills of negotiation. And when I was taught, went on a training course actually to learn about negotiation and the skills of negotiation, these are the kind of things that I remember being taught. Prepare properly, identify the issues, understand what your interests are, but also understand the interests of the other side and what your goals are and what their goals are. What is it they're trying to get? And have a discussion. That's all negotiation is, a discussion. Some people sometimes think what a discussion is shouting at the other side until they give in. The discussion is not about that. Discussion is about sharing a conversation, exploring interests, trying to find some mutual territory which you can actually agree upon. Explore each other's needs, understand what the other side's position is, and try to avoid ending up in a narrow mindset. And of course, understanding negotiation, also you need to understand how to formulate your agreement, how to get that agreed solution into a settlement that can be legally binding. Next slide, please. I think we need to go back one. Sometimes negotiation is not possible, and mediation I would describe as facilitated negotiation. And that means that it gives people who want to negotiate, wants to find a solution, help. And it involves the intervention of a facilitator, somebody who facilitates that negotiation. A mediator doesn't decide a dispute. The role of the mediator is to enable the parties themselves to find their own solution and to decide the outcome of their dispute. And the skills of the mediator to facilitate that negotiation, to ensure that there is no deadlock, to try and undermine entrenchment that sometimes parties get themselves into a corner and they won't get out of it. And the skills of the mediator are very much around moving parties away from that and into a structured and positive and meaningful discussion. Next slide, please. These are just the kind of a descriptive of mediation that you'll often find if you attend a mediation training regime. What is it? It's about having somebody who's trained in mediation techniques. Let me be honest about this. Anybody can act as a mediator. Anybody who's ever been involved in a relationship has probably been a mediator at some point or other, whether they've been married or otherwise. In the context of construction disputes, having somebody who's trained in mediation techniques is probably a good thing to do rather than have somebody you just think might be a good mediator. It's a voluntary process, generally, because what it really needs, mediation, is for both sides to properly engage in it. It's difficult to have a mediation if the parties are not volunteering to talk to each other, not volunteering to engage in the process. What's good about mediation as well is it's unlike court, where a decision is made when a judge listens to both sides' arguments, evaluates their evidence, and then makes a binding ruling based on which party they think has been the most persuasive. The whole focus of mediation is about focusing on practical solutions, common sense solutions, commercial solutions, planning for the future, and finding solutions that both parties can live with. Don't necessarily mean both parties like, what both parties can accept, and both parties can move on and get on with their lives. Mediation as well, it's flexible. It's not bound by rules. They don't have procedural rules in mediation. You can do mediation all types of ways. And in this slide here, I refer to the facilitative or the evaluative role, but there are different ways and approaches you can adapt or adopt in terms of mediation. The facilitative approach is very much light touch. The mediator's there just to help push the conversation along, where the evaluative role is the mediator is a bit more hands-on and maybe offers some of their expertise or knowledge, subject matter knowledge, into the discussions to help things move forward. Next slide, please. Adjudication has been referenced today in a couple of presentations. I've been involved with adjudication since it started. In fact, I was involved in helping to formulate the way RSCS set up as an adjudicator nominating body. RSCS currently appoints something like 1,200 adjudicators each year under the Construction Act. The Construction Act came into full force on the 1st of May 1998, and it's now basically the go-to form of dispute resolution for the construction industry. And adjudication has been so successful here in the UK that it's also been adopted around the world. And I've been fortunate enough to spend some time working out in places like Australia and Canada, where they also have statutory regimes that draw on the UK model for adjudication. Now, I can say here that the UK model for adjudication works far better here than it does in other jurisdictions, because even though they've borrowed from the UK model, they often tinker with it. And in tinkering with it, I think they've made it in their jurisdictions too complex, too complicated, and too many steps. The UK model of adjudication under the Construction Act is pretty simple, pretty straightforward. It just involves the appointment of an impartial adjudicator who's an expert in the subject matter of that's in dispute, and that person makes a decision in a timetable. 28 days can be extended, but pretty quick, and certainly much quicker than if the matter went to court. The thing about adjudication decisions as well is that they're binding and can be quickly enforced. The courts throughout the history of adjudication in the UK since 1998 have been very quick to support and enforce adjudication decisions and very reluctant to interfere in the adjudication process per se. Next slide, please. It was generally thought that adjudication was designed to deal with small bite-sized construction disputes. But over a period of time, over the 26 or 27 years that adjudication has been used in the UK, it has actually developed and evolved into something that is a bit more sophisticated than initially it had been. And you now see adjudication used quite a lot to decide larger, more complex matters. Adjudication in the UK is statutory. When I say it's been adopted in other jurisdictions, in Australia and Canada and in the Republic of Ireland, it's been there's a statutory regime that's been developed around adjudication, but other countries also have contractual adjudication. And one I could think of in particular is Southern Africa, where RSS has been doing quite a lot of work on the dispute resolution sector for some years. The process of adjudication, even if it's supported by statute, is of itself contractual, in the sense that what the statute does is provide a contractual right for parties to have any disputes arising under their contract decided by an adjudicator, an independent adjudicator. And if a contract doesn't include any reference to adjudication, then the law in the UK implies adjudication into the contract. So even if you have a contract that has adjudication scrubbed out, then it doesn't matter, because adjudication is there by virtue of regulations, the Scheme for Construction Contracts, which sets out the adjudication timetable and process, and it defines the obligations on the parties and the adjudicator, but also the powers that the adjudicator has to make the matter happen and to deliver a decision. Next slide, please. Any dispute arising under a contract can be adjudicated, and it can be adjudicated at any time. And construction contracts of themselves have been given a very, very wide definition. There are some exemptions, of course, and occasionally matters go to court when a party would argue that the contract that they have is exempt. And one I could think of is where the contract involves a party who's a residential occupier and the works are predominantly on the residential occupier's property. But even then, there are occasions where the courts have decided that the contract itself is caught by the legislation and that adjudication can proceed. But generally speaking, for construction adjudication to happen, it must be a construction contract which is defined under the Construction Act 1996, and all construction contracts, therefore, must provide for adjudication. Next slide, please. One of the roles I undertake on behalf of RSS is I sit on the Construction Industry Council ADR Management Board, which is currently chaired by a charter surveyor called Matt Malloy. And that ADR Management Board is also comprised of other organisations involved in the area of disputes, the Institute of Civil Engineers, structural engineers, but a whole raft of different bodies that are involved in the Construction Industry Council. And a couple of years ago, we were discussing, well, what can be done to improve adjudication, and that followed a government survey, a consultation, if you like, which, amongst other things, concluded that adjudication had become so complex and to an extent so costly that smaller businesses were feeling disenfranchised and couldn't use it. And the CIC ADR Management Board then decided to set up a working party to create a framework for adjudication which complied with the Act. So that means people didn't have to opt out of the Act and into this framework for adjudication, which could deal with lower value disputes. And for my sins, I was appointed as chair of that working party, and the CIC low value disputes model adjudication procedure was launched about 2.5 years ago, and it was relaunched again once it had been refined and improved. Effectively, it's about dealing with disputes where the amount in dispute, the claim, if you like, is less than £100,000, and the issues are relatively straightforward. I have to say we had a long discussion about what we actually meant about a low value dispute, what was low value. And though we settled on a sum of £100,000, we also included within the framework that if a dispute was pretty straightforward and it involved significantly more than £100,000, parties could still avail themselves of the low value scheme. The procedure itself, as I say, is compliant with the Construction Act. When it first came about, we found that some respondents were saying they didn't want the adjudicator to adopt the low value model because they felt that there was some reason they didn't want it. Perhaps they didn't want adjudication to happen at all, so they're just kind of reluctant about adopting the scheme. The message we've now been able to get across is that it's not up to the parties, it's up to the adjudicator. The adjudicator has statutory power to decide the procedure that the adjudicator is going to adopt, and it doesn't need the parties' permission to do so. So if the adjudicator feels that a dispute lends itself to the low value model scheme, then the adjudicator can adopt that scheme and require the parties to follow it. The benefit of the low value scheme is that the fees are capped at £5,000, and each party normally pays their own costs, and the adjudicator in most circumstances will require the parties to pay half that £5,000 fee, which is significantly lower than what we were finding in some of the more complex value disputes. Next slide, please. A few words about arbitration. Arbitration used to be much more commonly used to resolve construction disputes here in the UK. When adjudication came about, the numbers of arbitrations effectively fell off a cliff, but it's still used, particularly in some of the larger, more complex disputes, and it still has a place in the spectrum of ADR measures that can be used. It enables parties to deal with more sophisticated, more complex, more high-value disputes. There is no strict timetable for dealing with it. The disputes, it allows a much more detailed assessment and evaluation of the issues, of the parties' evidence, and it leads to a legally enforceable decision, which effectively means that if a dispute is arbitrated, then parties can't say, well, I don't like that, and then go to court and have the same dispute decided by a court. Once you have an arbitrator's award decision, that's the end of the matter. And just like in court, an arbitrator's decision is not based on the arbitrator's any investigation or inquisitorial method undertaken by the arbitrator. It's not that at all. It's very much about the parties trying to persuade the arbitrator by putting forward their evidence and their arguments either in writing or at an oral hearing, and the arbitrator then deciding who's been the most persuasive and making a decision. Next slide, please. Key features of arbitration is that the decision is binding. As I say, you can't then go to court. It's not provided under statute. Parties have to put an arbitration agreement into their contract. If there's an arbitration agreement in their contract and one party starts an arbitration, the other party can't wriggle out of it and go to court, because the party who starts the arbitration can then apply to court under Section 9 of the Arbitration Act and say, please stay proceedings, we want to arbitrate. That means that the courts in those circumstances will normally stay and order the parties to adhere to their arbitration agreement. Arbitrators tend to be experts in the subject matter that the parties are arguing about, which of itself is a real benefit to them, because having an arbitrator really understands the issues and understands what it is that the parties are saying gives parties confidence that the outcome is going to be one which is commercially sensible. A real key benefit of arbitration over going to court is, again, it's much more flexible as a process. The proceedings are confidential. Also, the parties can actually decide the proceedings and the timetable. They're in control of over that under the provisions of the Arbitration Act. Next slide, please. I mentioned at the outset of this presentation, I was going to say a few words about conflict avoidance and the growing appetite that we at RSES are seeing in the industry, or right across the industry, for measures that actually deal with disputes much earlier and much quicker than arbitration and mediation, adjudication, those other measures that I've talked about a moment or two ago. But I think part of the reason for this is that by the time you get to an arbitration, you will have already spent a lot of time and money and costs. To the extent that also you're probably in a position where you've lost control over the outcome because you've handed the whole process over to lawyers, and lawyers do what they have to do. They have to act in your interest. They have to do what's right for you in the legal sense. And they have to get into a position where they're going to fight your case. By the time you get to arbitration, you would have spent money, you would have taken a lot of time. So why not try and avoid arbitration in the first place if it's at all possible? Now, what we're seeing in the industry, and when I say in the industry, there are organizations that are really started to embrace this concept of avoiding conflict if possible, but managing it much earlier. And they include organisations like Transport for London, Network Rail, the Houses of Parliament Restoration and Renewal, the National Health Service. And these are organisations that we at RSES have been working with, who are really keen and have actually adopted and adapted forms of conflict avoidance, such as these I've listed here in this slide. The RSES conflict avoidance process. It was initially developed for Transport for London and was used on the refurbishment of the London Underground and some of the underground stations around London, and it proved to be immensely successful. And there's a few slides I'll show in a moment where I just use as a test study, if you like, just to show just what it was that Transport for London were looking for and how the conflict avoidance process met those needs. Early neutral evaluation is something that, again, has been supported. The Technology and Construction Court, for example, has a facility where it can encourage, if not order, parties to use early neutral evaluation, which is effectively a risk assessment exercise. It's where somebody who really understands what it is that the parties are arguing about gives them an opinion, on the merits of their argument, the merits of the case, and where it's likely to end up if it does go to trial. And they can use that information then as a platform to negotiate their own settlement. Dispute boards. This is something RSES has been very much engaged with outside of the UK in particular. Dispute boards are a mechanism that's used through the lifetime of a project, whereby a panel, and the panel could be one person, could be 3 people, could be 5. I've actually seen larger than that when on some of the really, really large projects where there might be 7 or 9 people appointed. But effectively, it is a panel which is there through the lifetime of a contract that helps to identify issues very early, helps to address those issues very early, talks to everybody, not just the employer, but the clients, the contractors and the subcontractors, and helps to ensure that any potential disputes are spotted early, and if they do arise, to deal with them early during the contract process. It's been used, as I say, extensively outside of the UK, but it's also starting to gain real interest now here in the UK. Next slide, please. I could have saved myself all of what I've just said by just showing you this one slide. This was created by Jonathan Cope, who is a partner of Matt Malloy at MMCS. Jonathan is former president of the Society of Construction Law, or chair of the Society of Construction Law, works very closely with RICS. And about a year ago, we asked him to give a presentation on different forms of dispute resolution and comparisons between the purpose and the key benefits, the strengths and the weaknesses, if you like. And he came up with this slide. And I think if there's anything for you to take away from this presentation, this slide, I think, would be ideal reference. It's very, very helpful, very, very succinct, and gives you a real sense of what each conflict avoidance and dispute resolution process brings to the table. Next slide, please. This whole appetite for conflict avoidance has really, really grown over the past few years. And to that extent, a coalition has developed. And that coalition includes these organizations that you can see listed here on this slide. But actually, there are a few more on there. And the ones I can see are missing are organizations like the Environment Agency, for example. The coalition has been around for a few years. Its aim is really to help encourage the construction industry, organizations involved in the construction industry, to embrace the concept of dealing with disputes much earlier by adopting processes like the CAP process, like dispute boards, like early neutral evaluation, or indeed like mediation early on, as ways of ensuring that disputes don't end up costing so much that the project is delayed for an unfortunate amount of time. The coalition has been around for a few years now, and it held its first full conference hosted by the Houses of Parliament about a year ago. And it's having its second conference, which is being hosted at Places Hall in the City of London on September the 16th. Anybody interested, please do just go onto the Conflict Avoidance Coalition's website and have a look and learn a little bit about what these organizations and other organizations are doing to try and improve the way the industry addresses disputes going forward. Next slide, please. When the coalition first met, I remember being at the ICE's offices when we all sat around a table, and we all had this immense desire to try and change the way the construction industry deals with disputes. And we were wondering, what do we do? What's the best thing that we could do as a coalition? And somebody came up with the idea of a pledge that an individual, a business, an organization, a government entity can sign, which would commit them to doing their level best to avoid conflict and facilitate resolution of disputes early, and to work collaboratively to recognize the value of putting conflict avoidance and conflict management measures into the contract to deal with disputes early. When we wrote the pledge, and this is the wording of the pledge here, we had a good audience. We had senior directors from Transport for London, from Network Rail, from the Houses of Parliament Restoration Project. And of course, if we found a form of words that they were ready to sign up to, then we knew we got it right. The pledge has been around for a few years now. All those organizations have signed it. Hundreds of organizations have signed it. And indeed, it has become government policy to the extent that it is identified in the construction playbook. In the playbook, it's encouraged to the point of comply or explain why you haven't. And all parties involved in public works projects are encouraged to sign up to this pledge. I remember being at an event in Scotland where somebody from the back of an audience shouted at me, "Why should I sign the pledge?" And luckily for me, there was an official from the Scottish Government stood next to me who was much quicker off the mark than me. And he said, well, why wouldn't you? And that's a very good point, actually. If you read what the pledge says and you identify the key points, the question is, why wouldn't you sign the pledge? You know, what would prevent an organisation or entity from saying, well, this is something I disagree with? Next slide, please. These are the main things that the pledge covers. I'm not going to go into detail here. Hopefully these slides will be shared with you because we're getting close to time. I just want to move on to the next slide. I mentioned a bit of a case study. I mentioned Transport for London a few times now. That's, I suppose, when I started to get involved in this whole concept of conflict avoidance and conflict management. Transport for London came to RSCS with 4 of their key project delivery partners and asked us if we might help them develop a method where they could avoid unnecessary references to adjudication, arbitration, or indeed litigation. And these were their desires. They just wanted to avoid the same old situation where you know, the whole language of the contract was about us and them and win and lose and effectively gearing up for a dispute. What they wanted was certainty outcome. They wanted the whole thing to be much more collaborative, the project to be delivered on time, and for contractors, they understood this, to be fair to them, that contractors should make a fair and reasonable profit. Next slide, please. RSS got involved by developing the process known as CAP, the conflict avoidance process. I'll explain it in very simple terms. You imagine the boardroom and the client is on one side of the table, the contractors on the other. They've been to and fro in for maybe a couple of weeks about a particular issue they can't agree with. And in normal circumstances, what you might expect is one of them to look to the far end of the boardroom table at their lawyer and give the nod to the matter going to adjudication. And that's it then. These commercial people then lose control. The lawyers take over. The matter goes to adjudication. They're at loggerheads. They're arguing with each other. They're fighting. And the whole idea was, well, how can we put a safety net in place of that? And the safety net was very much about putting a neutral person who had subject matter expertise, who would come in, look at the problem, act inquisitorially, go down to the site if necessary and talk to the people on the ground, come back with a report, setting out the answer to the question that the parties were grappling with, a neutral answer, and recommendations for settlement. And this was brought in about 2016 was the first time they started to use it, Transport for London. And this slide is Transport for London's slide. It's not my slide. It's one that was produced by the project, the director of projects at Transport for London at the time. And you can see the effect that it had, the immediate effect it had on compensation events and disputes. Next slide, please. I think this is more or less my last slide. Just wanted to say that this whole move towards conflict avoidance and better management of disputes and improving collaborative working is something that is growing at a phenomenal rate. It's, as I say, now embedded in the construction playbook. It has been adopted by organisations like Network Rail, UK Parliament. The Scottish Government have issued practice notes encouraging parties to sign up to the pledge and to adopt conflict avoidance and conflict management methodologies and measures. The work RSS is doing here in the UK has reached the ears of other organisations, including the Abu Dhabi government, which has not only adopted conflict avoidance CAP process, but also dispute board methodology, and has produced a whole raft of new contracts which include mandatory use of dispute boards. And conversations we're also having with Infrastructure Ontario in Canada, which has been having problems around their transport system and works there, and have adopted or conflict avoidance methodology as the way forward, rather than allowing those disputes to end up in court. Now, I think I've raced through that presentation. I'm a little bit out of breath. I don't know if there's any time, Richard, for any questions going forward, but happy to take them. If not now, then feel free to put them in the chat box or by email, and I'm happy to respond.
Fantastic. No, that was absolutely brilliant, Martin, and thank you very, very much for trying to condense and span quite all of that in one session. It's been absolutely brilliant. I've got some questions, but there's one that's just come in from Marion. I don't think Marion's surname is iPhone. I think that must be her iPhone, so I'm not going to make that mistake. But she asks, are there any plans to review or explore better cap for disputes with consumers?
Disputes with consumers. In my job, in fact, I've been working very recently with the organisation Which, the consumer organisation, and Which came to RSS with a request to see if we could help them with their trusted trader scheme. Because what they wanted, the trusted trader has been an absolute winner for them in terms of the consumer confidence that it's entailed. And we worked with them to develop a bespoke form of ADR that kind of draws on cap principles, but draws also on adjudication. And it enables disputes between consumers and traders under the trusted trader scheme to be dealt with very, very quickly, no cost to the consumer, minimal cost to the trader. We're talking a couple of £100, which have been using it now, I think, for a little over 2 years. And with the feedback we've had is that they absolutely think it's brilliant. So the consumer market is something that now RSS is looking at in a much more broader terms. So, well, if it works for Which, what can we do to help other areas of the consumer market?
Yeah, absolutely brilliant. I've got hopefully a quick question, but one that I'm kind of interested in. So, if negotiating on a without prejudice basis, is that something that has to be agreed in writing by both sides before offering concessions or solutions, or can a without prejudice offer be made unilaterally?
A without prejudice offer can be made unilaterally. You can have if you're going to have without prejudice conversations, you need to make sure that both sides understand that these conversations are without prejudice. Otherwise, what you're having is an open conversation, and another party could say, well, Richard said that to me. He made that offer in that conversation at 2:00 on Friday. You need to be very clear that, the conversation itself is meant to be confidential and not to be prejudiced by any sort of court or other judicial proceedings. Without prejudice offer, you can be having a general discussion and negotiation. But if you want to then make an offer to settle, but you want that offer not to prejudice any further future court proceedings, then you need to make sure that it's labelled without prejudice. There are certain protocols you need to go through in terms of making without prejudice offer. It needs to be a proper offer. It needs to be marked without prejudice, and it needs to be properly timed. You can't say you need to settle by 4:00 this afternoon, or else it's withdrawn.
Fine. So there's obviously, yeah, absolutely, but really useful to understand more clearly. Final question from me. I was at another CABE conference in Malaysia, actually, at the International Arbitration Centre in Kuala Lumpur. And one of the sessions there was on expert determination. And I wondered what your views are about that approach, which was being suggested as another way in which to kind of quite quickly and affordably resolve technical issues.
I'm a great believer in parties having the choice of using a dispute resolution measure that works for them, whatever it might be. Expert determination has been widely used in the commercial property sector to deal with rent disputes for a long, long time, and it works very well. It's been used less so in the construction industry. I've rarely seen it used in the UK construction industry, possibly because it in some ways it's very similar to adjudication. You have somebody who's a subject matter expert who's making a decision, who has some powers of inquiry, but also takes evidence and arguments and then makes a decision, and it's fully reasoned. So the main difference, I suppose, is the way adjudication is very much timetabled. whereas independent expert determination is not. But the point I make is that if expert determination is something that parties think works for them, then use it. And it is hugely popular, less so in the construction industry than it is perhaps in other sectors in the built environment.
Fantastic. Well, look, that brings this session to an end. If people have other questions, please submit them to us either by email or in the chat, and we will pass them on to the session speakers. But thank you, Martin, very much. I hope that we get to work with you again in the future. It's been a real pleasure and a fantastic closing session for today's event.
Thank you, Richard.
To everyone else, I'd just like to say thank you very much for attending. I think we've had the benefit of a fantastic range of speakers and topics today, and I really hope that you found this useful. We'll be repeating these, the legal session and the online sessions that we're currently running every year. So if you have topics that you are particularly interested in us finding speakers for, please get in touch through the usual channels, and we will do everything we can to get similar subject matter experts here to give you the kind of briefing that you feel you need. Please do, if you are local, think about coming to our Wales and Ireland face-to-face events and the Building Control event in England next year. But also, please don't forget to log on to the remaining online events for this year, so fire safety and health and safety, which will be launching fairly soon. All that remains is for me to say thanks again to all of our absolutely brilliant speakers and to wish you all the best of the rest of the day, and to say thank you and see you again soon. So thank you very much, and goodbye.